For reasons mentioned in the judgment, this criminal revision petition is dismissed.
Delivery of order, item number 1.
For reasons mentioned in the order, this interlocutory application is allowed and the delay of 119 days in preferring the connected regular second appeal is condoned. The registry is directed to register the connected regular second appeal and list the same for admission hearing after 7 days on a date to be fixed by.
Item 2 and 3.
For reasons mentioned in the order, petitioner in both the cases are allowed to go on bail of rupees 50,000 each with one surety of like amounts with certain conditions.
My Lordship, to accept my written argument in civil revision petition 83 of 2025. Opposite party filed on 21st January, Lordship. He was granted to file.
Submitted.
I want to mention a regular first appeal of 2018. So partition matter, mother expired, but appellant side did not file substitution application. Matter is pending since 2018. May I pray for listing in order column?
Orders column. When?
Friday, Lordship.
Oh, senior court is there. You have to, for listing, you have to mention before senior court.
Highlight.
Goes on. Item 22 from supplementary list.
Please, your Lordship.
Yes.
Lordship, with a very limited prayer, through this application is filed for your Lordship. First of all, your Lordship, the panel of C. Is that herein are the partners of respondent number 1, my lord. They are the partners of respondent number 1. In terms of partnership deed, your Lordship, the panel of C. Deed of partnership I have annexed. Agency number 9, page 214.
Yes.
Page 214, my lord. Relevant portion is 218, my lord. Very, my lord, in this partnership form, the petitioners are having shares of 40% and 20% respectively, wherein respondent number 2 is having 40% share in the partnership form of respondent number 1, my lord. This partnership form was reconstituted, my lord. Your Lordship cannot see annexure 10, page 227, my lord. Page 227, my lord. Herein the shares of the partners have been defined, according to which, my lord, 75% of the shares of this firm belongs to the single and family, my lord, and only 20% is held by respondent number 2, which is wife, my lord. So this is the partnership firm, my lord. My lord, in respect of this partnership firm, there is a bank account, my lord, which was operated by respondent number 2, my lord. During the operation, it was detected that some misappropriation of funds had taken place to the hands of respondent number 2. Then, my lord, the petitioners had filed the application before the banker for re-verification of the signatory of the account, my lord. Then immediately, my lord, account at time, my lord, petitioners have prayed for freezing the bank account in view of single-handed operation by respondent number 2. Account was freezed, my lord. Then matter was amicably settled between the parties, my lord, by way of annexure 1, your Lordship cannot see. Annexure 1, Page 18, my lord. The dispute between the petitioner partners will settled, my lord, by virtue of this conciliation agreement, my lord, under section 73 of the Act of 1986, my lord. In between, my lord, respondent number 2 was allowed to operate the bank account till separation of the shares of the partners in the joint property of the Protect Group of FF, my lord. Thereafter, my lord, without complying this MOU, my lord, the respondent number 2 had filed an application under section 9 of the Act of 1996, my lord, Annexure 2, page 21, my lord.
Yes.
In this application, my lord, the respondent number 2 was succeeded in obtaining an ex parte injunction order. Of quoted portion of this order, your lordship may cannot see. Page 62, my lord, internal page number 14. These were the reliefs granted by the learned High Court. Upon application under filed under section 9 of the Act of 1996.
Page
With-
number?
Page number 62, my lord. 62. Internal page number 14 of the order.
Yes.
Surprisingly enough, my lord, before going to the this order, my lord, your lordship may cannot take a judicial vote. While filing this application under section 9 of the Act of 1996, this deed of settlement conciliation deed was suppressed before the trial court. According to which, my lord, the petitioner number 2 are not having any vested in legal rights in respect of the assets and liabilities of respondent number 1. In spite of that, suppressing the said fact, my lord, this order was obtained. This is the order, my lord, which the learned trial court was pleased to pass. My lord, I am reading paragraph 15 of the order, my lord. In accordance with the principle of justice and equity, this court finds it imperative to issue an adjudicative injunction order under following terms. An order of adjudicative injunction to defreeze the current account number so of the petitioner number 1 firm held with OP number 2 in the same bank, Galaguri branch, and debit payment request made concerning transactions of the said bank account prior to the date of freezing. An injunction to restraining OP number 1 from taking any action for closing, freezing the transaction of the bank account of the petitioner number 1 from post defreezing of the said current account. This order was obtained, my lord, on 9/12/24, my lord. In this order, my lord, next date, your lordship, I cannot see next page number 64. Next date was posted on 9/1/25 for filing objection. On 9/1/25 itself, the present petitioner had filed their objection before the trial court, my lord. Thereafter, matter was not taken into consideration for disposal as required under order 39(3). 3A, my lord. Matter went on, my lord. Having no other alternative, my lord, the petitioner had filed an application. In Annexure 5, your lordship, I cannot see page 99. In Annexure 5, page 99, my lord. An application for modification of ex parte injunction order dated 19/12/24. This was filed on 21/2/25. Annexure 5, your lordship, page 99.
Yes.
This application was filed on 21/2/25, my lord, for modification of ex parte injunction order. Surprisingly enough, my lord, this petition has not yet been disposed of by the learned trial court, in spite of fixing the matter for almost 25 dates for hearing. Your lordship cannot see Annexure 8 series, my lord. These are the order sheet made by the learned trial court in respect of this application. Annexure 8, my lord, starting from page 183, my lord. 25 days have been posted for hearing of this petition. No hearing took place, my lord. I am in this proceeding, my lord, already written argument has been filed by the petitioners before the trial court long back in the month of June. Annexure 8, my lord, page 183, my lord, first date of hearing was posted on 9/1/25. This was first date, my lord, for SR. An objection, my lord. Thereafter, my lord, matter was posted for hearing. Since, my lord, your lordship, I cannot see page 188. Objection hearing on 18/3/25. Page 188, my lord. Since then, my lord, repeatedly matter was posted for hearing, my lord, but hearing was not took place before the learned trial court.
Objection hearing on your petition.
On my petition as well as main petition under section, filed under section 9 also, my lord. Analogous hearing was posted because on my application, no separate this case was registered, my lord. This was tagged with the main section 9 application.
No, why hearing is not taking place?
Your lordship, I cannot see, sometimes they used to take time, my lord, sometimes in the meeting, my lord, there were on two occasions.
Sometimes you take time, sometimes they take
No, my
time.
lord, in this matter, during this proceeding, my lord, there were two occasions for transfer of the land presiding officer.
Okay, now what do you want?
My lord, matter has been posted tomorrow, let it be decided by the trial court, my lord. This is my simple prayer before your lordship. On merit, my lord. Matter has been posted tomorrow for hearing.
Then let us fix it. Yes, mister.
My lord,
Your only prayer is for
Prayer-
expeditious hearing.
As the matter has been posted tomorrow for hearing. In the meantime, my lord, the present petitioner has filed written argument.
Why
Bank-
hearing is not taking
Bank
place?
is involved, my lord. Bank has also filed their written argument, my lord. Now only respondent number 2 is to argue the matter, my lord, before the trial court.
Yes.
but I'll just quickly point out, my lord, otherwise I'll leave it to your lordship's discretion insofar as expeditious disposal is concerned. Because their prayer is at page 15, my lord. The matter is already fixed tomorrow for hearing. And
Yes.
they want a direction for it to be decided within the next day. Now, this process, this file process over 2000 pages, my lord. It's not humanly possible to do that. That's number one, my lord.
What is the prayer?
Page 15. my lord. Because otherwise I'll show from the records, my lord, I have taken date just once. The record was transferred twice and the presiding officer was
No,
transferred
he-
thrice. In fact, the entire order sheet will show that I've taken just one adjournment. My friend has perhaps taken two. The matter could not be taken up because the presiding officers were successively transferred and the record was also transferred twice, was reallocated. Now, Lord, my lord, matter is already fixed tomorrow, my lord. In fact, my lord, if I may just take a moment to place
No,
that.
we will not go into merits.
I will not address on merits at all, my lord. I'll not address on merits. my lord.
If the matter is fixed tomorrow, there is no reason to doubt why hearing would not take place tomorrow. So we'll fix this matter after tomorrow, with a hope that
Trial court shall decide the same tomorrow, my lord.
not decide, conclude the hearing tomorrow.
My lord, my friend took 3 days to argue the matter last time when
Yes,
I argued.
yes,
argued.
that
So
court will
tomorrow,
decide.
let the hearing commence, my lord. We've not taken adjournment. I'll show from the record, my lord.
My lord,
Now,
How much time trial court takes, it is for the trial court to decide.
exactly, that is what, my lord, the Supreme Court has recently said, that these applications under 227 asking for expeditious disposal should not be entertained, my lord. In fact, while reviewing that Asian resurfacing judgment, my lord, I'll just place 2 paragraphs, my lord. Why? Otherwise, my lord, I'll leave it to your lordship, but this is what.
No, what is your prayer, Mr. Alam? Tomorrow it is fixed.
for hearing, let the hearing be concluded tomorrow, my lord.
Why hearing would not take place
My
tomorrow?
lord,
We
this is our
don't.
partly, and for the hearing, my lord.
No, they have not finished their part.
We have filed written argument, my lord. We need not to argue.
No,
my
no,
lord.
Your lordship.
Mr. Alam, I don't understand why you have rushed to this court when hearing is fixed tomorrow. If tomorrow hearing does not take place, then there might have been some reasons.
This is in continuation since 12 March 25, my lord. That's why, my lord, under compulsion, I have come to this one. court,
But
my
why, my
lord.
lord?
Matter has been
Because
posted
the
for hearing,
judge,
my
my
lord,
lord,
since 12 March 25, my lord.
my
Almost
lord
one
will
year.
see
one
the
year
order
going.
sheets, my lord. That's.
I placed the order sheet, my lord. Since 12 March, matter has been
My lord,
posted for hearing,
let,
but
let,
no
let
hearing.
the
took
hearing
place.
commence, my lord. But to get an order from here, so as to exert pressure on the subordinate.
No, that is
That is not
improper.
my intention, my
That
lord.
is improper. It is for the trial court
Court to see.
to see. Heard Mr. N. Alam, learned counsel for the petitioner. Also heard Mr. B. D. Deka, appearing for the caveator.
Respondent 1, 2, and
Respondent number
1, 2, and 3, 1 to 4.
1 to 4. This this application under Article 227 of the Constitution of India has been filed by the petitioners for issuance of a direction to the trial court for deciding the application filed by the present petitioner, which has been numbered as petition number 968/2025, praying for modification of the
Order dated 19/12/24.
order dated 19
12/24.
12/24, passed in misarbitration case number 2020 205/2024. Stop. Learned counsel for the petitioner submits that the petitioner had filed the aforesaid application for modification of order dated 19/12/2024 way back on 21/2/2025. However, after filing of the said application, the trial court fixed the matter on 25 occasions, but the application filed by the petitioner for seeking modification of order dated 19/12/2024 is still pending. He therefore prays for directing the trial court to decide the modification application on the next date, that is tomorrow. Stop. Learned counsel for the caveator respondent submits that the respondent side has no objection in the expeditious disposal of the misarbitration case number 205/2024. However, as the matter is fixed tomorrow for hearing, it may not be appropriate for this court to issue any direction at this stage. And in support of his submission, he cites a ruling of the apex court. Which one?
My lord, High Court Bar Association, Allahabad versus State of Uttar Pradesh.
High Court Bar Association, Allahabad versus State of Uttar Pradesh, reported in
2024, 6 SCC 267.
2024 6 SCC 267. Stop. Stop. Since I have considered the submissions made by learned counsel for both sides. Since the misarbitration case number 205/2024 is fixed for hearing before the trial court tomorrow, that is on 28th of January 2025. This court hopes that hearing would take place tomorrow and the matter would be expeditiously decided. Hence, at this stage, it does not intend to pass any orders. However, this court also does not dispose of the instant civil revision petition today and fix it today. Stop. Let this matter be again listed. We are listing it again with a hope that when
2nd of February, my lord.
not second.
Well, notices perhaps also has to go to the bank and the other.
No, whether to issue notice or
This was
not,
the-
that will decide on.
No, as far as my prayer is concerned, my lord, no requirement of issuing notice because my lord.
Therefore, we are not issuing
My lord.
notice. We are also not dismissing it.
Bank had already filed it in argument.
Third and fourth, any date, no, not on second.
Let it be on 3rd, my lord.
Third.
3rd of
Let,
February.
let this matter be listed on 3rd of February. Again in motion column.
Blind.
This one. And then
Much more.
May please your lordship.
Lordship, in this matter, we have filed one affidavit last week, my lord, but it's not on record.
Look, I
It
have
may be
cop-
called for.
I am furnished two copies.
I have furnished
one
copy.
copy. There is nothing there.
Affidavit is in-
I get the point of memorandum, there is nothing. I am furnished two copies. The lordship is say one copy.
But that affidavit has to come on. You have a copy of that.
I have two copies. I can give one copy if your lordship. wants.
Diokson. But, okay, what will we do? We will take it up after some time. Let the registry send that affidavit. We'll take it for admission hearing today itself. Okay,
I am highly obliged.
affidavit to Fuji Pathao after some time.
Item 5.
But the matter arises out of a suit instituted by me. This was for specific performance of an agreement for sale. Now, during the stage of evidence, my lord, when PWs were being recorded, we had filed 4 different applications seeking for adducing evidence through official witnesses and documents. These 4 applications, my lord, are there as annexer 7, 8, 9, and 10. Sorry, my lord, 8, 9, 10, and 11. The first petition, my lord, was seeking for certain records from the ZMDA. The second was, my lord, to adduce official witness from the circle office. Third was, my lord, to call for certain documents from the Guwahati Municipal Corporation. And fourth was to, my lord, call for the sub-register to prove the deed, my lord, which was a registered agreement for sale, which is actually what I am seeking to, my lord, specifically seeking specific performance of. That particular original is still in the sub-registry. I call for that particular document. Now, while other applications were issued, my lord, were allowed, the court had declined to, my lord, entertain my application for calling the official witness of ZMC and the sub-register, my lord. The applications number 1186, sorry, 1187 and 1189, they were rejected, my lord, by the impugned order, which is at page 114 and excess 17, my lord. The reason given by the court, my lord, is that as far as the sale, agreement for sale is concerned, the court says that I need not prove it because it is not in dispute. But in my case is that, my lord, I have to adduce the best evidence when the original is available, my lord, from the sub-registry,
No, but if they are not disputing it,
my lord.
whether they are disputing it,
No, no.
No,
then what is requirement to prove this?
my lord, the rule of evidence requires that I have to produce the best evidence.
No,
There
but
was no clear admission and denial. Had this been, my lord, that there had been a
No,
notice
what
to
do-
admit that particular document,
what do you want to prove? The existence,
the existence of the original sale date, my lord, sorry, agreement for sale,
agreement for sale.
agreement for sale, which is, my lord, I am
Are you
seeking
opposing?
specific-
No, Lordship. I am
They are
not-
admitting it. We will record the admission and dispose of this matter.
I have also sought declaration on same application.
In fact, they also would want to, they also would
The
need it,
question
my
of
lord. They
denial-
also need it, my lord. The original has to be before the court. not
Oh,
in the
why?
sub-registry.
Why?
My lord, because there was no application filed at that juncture, my lord, for admission and denial of documents. Had that process been done, clear admission would have been recorded. Do they rely on the same? I also rely on the same. The original, otherwise it is clearly admitted through process of admission and denial, my lord, would require to be produced. That is one aspect. And the second application was, my lord, this particular land, they are resisting the sale now by saying that this, my lord, is in a eco-sensitive zone and therefore some commercial activity and sale is, my lord, restricted. What I wanted to prove, my lord, by calling from documents from the ZMC is that there are existing commercial shops of the over that particular land. And therefore, I wanted to only call for the trade licenses from the ZMC to show that this land, which is though otherwise in the
No,
Libreville, ecosystem
regarding 1186
My lord.
slash
my
2023,
lord.
what was the prayer?
The prayer was to call for, my lord, trade licenses from the ZMC, my lord.
Trade licenses for,
To show that, my lord, this particular property which is sought to be sold is actually being commercially used. And therefore, there is no bar in any law for sale of the particular land, even though it is in an eco-sensitive zone. Now, the relevance of these things, my lord, can be considered only after evidence is there. What the court had done is that what is relevant and not relevant as evidence, my lord, before I adduce evidence, my lord, this was decided. No harm will befall upon them, my lord. My official other witnesses have been called. If this come through, my lord, they can, of course, if they have any objection, they can cross me on that.
where is the reasoning of the
My lord.
court rejecting your application? 1186.
1186, Lordship of the Crown.
Mm-hmm. 1189 and 1187 will reject.
1189 is sub-registrar.
Lord, sub-register.
Petition 1189 and 1187 was rejected.
886 was allowed, my lord. 87, my lord, page 120. Page 120, para 16. The plaintiff had filed a lawsuit seeking performance of a contract and a permanent injunction against the defendant in this honorable court. Plaintiff claims ownership of a plot of land with 9 shops assessed and listed by the Guwahati Municipal Corporation. After an assessment, GMC allotted holding numbers on the said shops. Plaintiff has been paying corporation taxes regularly.
Okay.
Here again also, my lord, had there been actually at that stage, had there been a process of, my lord, clear admission and denial of documents, this controversies would not have arisen. The court again says that it is not disputed that there are commercial shops over there. But then since admission and denial did not take place, at the stage of order 16, my lord, I had filed this application saying that I need to now prove these documents. It's only to the extent of producing the same, my lord. And by now, my lord, it would have been concluded, my lord. It is still now hanging in the stage of PW.
Where is the error in the order?
My lord,
So as to justify interference by this court.
my lord, the error arises, my lord, had there been, my lord, a clear admission and denial of documents and contemplated under order 13, my lord, this would not have arisen. Since that process was not done, at the stage of order 16, when I call for documents, that these documents are to be
Order 10 was not followed.
not followed, my lord. It was not
Okay.
followed, not followed.
That is the only submission.
My lord, only to that extent. It's only just producing these documents, which otherwise are in existence and they do not also seriously dispute, my lord. But
Yes.
then how do I perfect my evidence, my lord? I have
Yes,
to perfect
Mr.
my evidence.
You are aggrieved with your rejection of petition number 1187 as well as
As well as, my lord, 1189.
1189.
Yes, my lord. 1189 was for calling the original of the agreement for sale, which is in the sub-registry. my lord.
And 1187,
Was for, my lord, calling for the holding numbers from the ZMC.
why this court should exercise its powers under 227?
My evidence would otherwise remain imperfect, my lord.
Okay, yes, Mr. Ali.
If your lordship kindly peruse my affidavit in opposition, particularly the issues framed by the learned trial court.
Hmm.
Start from page 122.
Page number?
122 starts my affidavit in opposition.
No, what is your response to his submission that if the petitions are not allowed, his evidence will remain?
Lordship, learned trial court on the basis of pleadings of both the parties, total 8 issues were framed. So out of those 8 issues, particularly for the plaintiff, issue number 2 and 3, whether the plaintiff is entitled for a declaration that the agreement for sale is binding upon the plaintiff and defendant. And next issue for directing the defendant to pay balance amount of rupees 50 lakhs out of total consideration of 70 lakhs. And for counterclaim, respondent, issue number 5 and 6. Whether the defendant is entitled to a declaration that the agreement for sale is not binding upon the defendant. And for realization of advance amount paid by the defendant to the plaintiff with interest. These 4 issues are core issues to decide the issue on the basis of pleadings of the parties. And then what happened? If your lordship kindly peruse the certified copy.
No, why you paid advance amount to the plaintiff?
Lordship, an agreement for sale was executed by the petitioner, who is a landowner, in my favor to sell out total 9 leases of land, lordship, at total consideration of 70 lakhs.
Okay, okay.
Out of that 70 lakhs, my client paid 20
Okay,
lakhs.
land belongs to the plaintiff.
Then the landowner did not disclose its restriction. The suit land is under the restriction of eco-sensitive zone. So this is not transferable. So that stand I have taken in my written statement, and the plaintiff adduced evidence, total 3 witnesses, and the plaintiff side, plaintiff who adduced evidence as PW1 admitted the same. And then the RTI reply issued by the concerned authority regarding restriction of eco-sensitive zone, that is admitted by the PW1, and that later was also exhibited as Exhibit 10 during the cross-examination of PW1. Now, to fill up that lacuna, they filed these 4 applications that is apparent from the order sheets. I have recently obtained this order sheets. This is not disclosed by my learned friend.
What order sheets?
If your honor kindly peruse first flag order dated 17/6/2019. On that day, they filed an application under Order 7, Rule 11 for production of that sale deed, agreement for sale. PO is on leave on that day. Plaintiff side filed evidence of PW1. Then they filed an application in last 2 line, lordship. Plaintiff side filed a petition under Order Rule 11, Order 11, Rule 14. So PO was in leave on that day, and thereafter that application was not pressed. And on next day, lordship will find order dated 29/7/2019. On that day, they filed PW2. And after filing all evidence, lordship will kindly peruse the order dated next second flag, lordship, 23/2021, second flag. An advocate commissioner was appointed, Mrs. Payal Chaudhary, for recording cross-examination. Then they took as many as 10/11 adjournment, and cross was not taken place due to repeated adjournment. Then kindly peruse third flag, Lordship, order dated 22/8/2022, third flag. On that day,
Yes,
next advocate commissioner was appointed, Lalita Bora. Before the earlier advocate commissioner, the plaintiff did not appear for cross-examination. Next, kindly peruse, Lordship, fourth flag, and handwritten order is there. So after cross-examination of all three PWS, the plaintiff filed these four applications: 1185, 1186, 1187, and 1189. These four applications were filed at the stage of DW1. If your honor kindly peruse order dated 16/12/2022. On that day, case was fixed for evidence of DW1. And while case is fixed for DW1, the plaintiff filed all these four applications.
yes.
And now kindly peruse my written objection filed against the application 1187. I have filed my written objection, Lordship, to showing all lapses of plaintiff side. They filed application for production of original agreement for sale in the year 2019 that was not pressed. Cross of all PWS was completed, and then at the stage of DW1, they filed application or 1187. And the learned trial court already issues frame to decide the dispute of both the sides. Then, Your Honor, that 9 holding number is not at all disputed, Lordship. This is not subject matter of the suit, Lordship. Therefore, the learned trial court rightly rejected the application 1187, holding that that particular 9 holding number is not matter in dispute. And my humble and respectful submission, Lordship, what is going to show by bringing that 9 holding number? To suit for specific performance, land is under eco-sensitive restriction, that is admitted. Now to fill up this lacuna, this application 1187 is filed. And since the matter, that holding number is not under dispute, therefore the learned trial court rightly rejected this application.
What was the prayer in 1187?
1187 to, Your Honor will find that application. That page number, Lordship, 79. Prayer portion at page 80. Under the above circumstances, it is therefore prayed that Your Honor would be pleased to consider the petition and allow the plaintiff to call for authority of GMC to prove the holding now to the 9 shop standing over the scheduled land by the Guwahati Municipal Corporation and adduce evidence before this honorable court for greater interest of the justice. So already
What trial court
trial court finding
held
admissible,
that?
find effective for page 121, Lordship. One 22, paragraph 20. Simple. Paragraph 20, page 122, Lordship. So suit for specific performance, that is not disputed.
And 1189?
If Your Honor kindly peruse 1189 application, Lordship will find that page 83. prayer person, Lordship will find at page 86. So prayer is not for production of original Lordship. Here at page 86, Lordship will find prayer person for production of authenticate copy of the agreement for sale. And to adduce evidence pertaining to execution of registered agreement for sale. So evidence already adduced, Lordship. They have also filed certified copy.
You are not disputing that
I am not disputing it.
because your claim is also based on that
That same agreement. for
same
sale.
agreement. Anything?
My lord, one thing, the issues are there, Lordship has seen, but the hidden and core issue here, why this commercial activity and other things have become necessary is that whether a sale transaction in an eco-sensitive zone and commercial activities can be carried out or not is one of the core issues which is hidden behind these issues. And now, therefore, my lord, to show that it is my case that there is no regulation and there is no bar of sale of a commercial property and commercial use in a eco-sensitive zone. And as of today also, it is used as a commercial land. So therefore, I wanted to adduce this evidence. Had it not been the issue of eco-sensitive zone, if it had not come up, what is there in the land is, my lord, irrelevant. But because the issue of eco-sensitive zone had come in, my lord, it has become relevant to show and produce that, yes, there are commercial activities being carried out in that particular land.
No, that was not your prayer in your application 1187.
My lord, I said that the holding numbers of the ZMC
Is to be.
is to be produced to
which-
show
Which they are not disputing.
the essence, my lord, is that to show that there are or there is commercial activity being carried out. My question is, my lord, I want to perfect my evidence, my lord. It's not that there is no bar in order 16 that
Okay,
I
heard.
cannot file these applications at this juncture. At any juncture, I can produce and the court can also look into. The court had allowed, therefore, the officials of the ZMD and other officials, 2 of my applications were allowed, my lord, on the same premises. But then these 2, my lord, the relevancy of my evidence was judged even before I adduced my evidence, my lord. Relevancy is a factor to be decided only if after I adduce evidence.
No,
That these are
No, you are
and
not
these are
right.
relevant, my lord.
unless the evidence is relevant,
Yes,
it is not to be allowed.
yes.
Reliability is to be judged later
Yes.
on, but irrelevant matters, for irrelevant matters,
No, prima facie.
gates will not be opened
Yes,
by.
yes, of course, I am not saying that prima facie irrelevant material can be introduced. The sale deed or the agreement for sale is, how can it be called irrelevant? How can the, my lord, the existing use of the particular land become irrelevant, particularly when this issue of whether commercial transactions can take place in a eco-sensitive zone or not is one of the core hidden issues in the matter, my lord.
To decide
This
that
cannot be,
issue,
this cannot be said to be irrelevant, my lord.
to decide that issue, Lordship, one application that is 1186 is already allowed. If your
Yes,
Lordship
since-
kindly peruse
Since one is
page
allowed,
number
the
117,
rest are also to be allowed, my lord.
page number 117, Lordship.
Okay, heard Mr. B. Pathak, learned counsel for the petitioner. Also heard Mr. R. Ali, learned counsel for the respondent. This application under Article 227 of the Constitution of India has been filed by the petitioner, namely Avtar Singh, impugning the order dated 16/8/2018 passed by the Court of Learned Civil Judge Senior Division Number 1, whereby the applications filed by the petitioner bearing number 1187/2023, praying for calling the officials of GMC and Guwahati Municipal Corporation to prove holding number 9 shops standing over scheduled land, as well as application number 1189, praying for issuing summons to Senior Sub-Registrar Kamrup Metro for production of authentic copy of the agreement to sale bearing registered deed number 1855 slash bearing registered sale deed. What is the number of the agreement to sale?
Deed number 1185 dated 24/2/2014.
What is this 2525? In page 86. Page 86, prayer portion. In the prayer portion, page 86.
Serial number 1855.
There is serial number.
2525.
The deed number
25.
is 118.
18.
Deed number 1855, serial number 2525, dated 24/2/2014. Stop. The facts relevant for consideration of the instant civil division petition in brief are that the petitioner has filed a suit for specific performance of contract against the respondent against the respondent. Stop. It is contended by the petitioner that an agreement to sale was executed by him in respect of land mentioned in the schedule to the plaint on 24/2/2014, which was duly registered before the Senior Sub-Registrar Kamrup Metro. And as agreed by both the parties, the consideration amount for sale was fixed at rupees 70 lakhs, and the respondent paid an amount of rupees 20 lakh as advance amount, and balance of rupees 50 lakhs was to be paid at the time of execution of the sale deed. However, it is contended in the plaint by the present petitioner that the respondent declined to cooperate in execution of the sale deed in terms of the agreement for sale, and accordingly the petitioner had to institute the suit for specific performance of contract and for permanent injunction. The said suit was registered as title suit number 5/2018 and is pending before the Court of Learned Civil Judge number 1, Kamrup Metro, Guwahati. Stop. It is pertinent to mention herein that in the aforesaid suit, the respondent as defendant also filed a counterclaim praying for a decree for realization of the advance amount of rupees 20 lakhs paid to the plaintiff by him, and also for a declaration that the agreement to sale executed between him and the plaintiff is not binding on the defendant. Stop. Learned counsel for the petitioner has submitted that during the proceeding of the suit, the trial court did not ask for admission and denial at the appropriate stage under Order 10 of the Code of Civil Procedure. And therefore, as there is no clear admission regarding existence of agreement to sale between the parties, the petitioner as plaintiff, in order to produce best evidence in support of his case,
It will be order 12, my lord, not order 10. Admission and denial is order 12.
Order 10, Order 12,
10 is examination of parties. 12 is 11 is discovery and inspection, and 12 is, my lord, admission and denial.
okay.
12(1) is notice to admit documents.
No, Order 10 only. Because it is under Order 10 during examination of parties, they will admit or deny.
My lord.
Order 10, Rule 1.
Allegations are, my lord. This to be read with, my lord, order 12. But then, yes, the examination of parties starts, my lord, from order 10, rule 1.
If
only,
at that stage it is admitted,
my lord. Then there's no necessity to lead evidence, my lord.
Order 10 as well as Order 12. Yes, it last para.
The petitioner has entered in order to produce best evidence in support of this.
Has filed 4 applications before the trial court, which were registered as petition number, which were numbered as petition number 1185/2023, 1186/2023, 1187/2023, and 1189/2023. Under Order 16, Rule 5, 6, and 7, read with Section 151 of the Code of Civil Procedure. Learned counsel for the petitioner submits that though out of the 4 petitions filed by the petitioner, the trial court allowed which of the petitions?
185 and 1186, my lord, were allowed.
One trial court allowed the petition number 1185 as well as 1186. However, it rejected the prayer made by the petitioner in petition number 1189/2024 for calling the officials of the sub-registry and production of the authenticated copy of the agreement to sale. He submits that the trial court also rejected the petition number 1187 for calling the officials of Guwahati Municipal Corporation to prove the holding number 9 in respect of the shops situated over the scheduled land. He submits that the trial court erred in rejecting both the petitions, as it observed that the existence of agreement to sell has not been disputed by the defendant side. The necessity of calling the authenticated copy of the agreement to sell is not there. He submits that since the procedure prescribed under Order 10 as well as under Order 12 of the Code of Civil Procedure was not followed in the aforesaid suit, and since there was no clear admission from the side of the respondent regarding existence of the agreement to sell, the petitioner only intended to produce the best available evidence in support of his case, and the trial court was wrong in rejecting the same by deciding the relevancy of the same even before the said authenticated agreement to sell was produced by the trial court, before the trial court stopped. He further submits that the production of holding number, the proving of the holding number in respect of the shops situated over the scheduled land as prayed for in petition number 1187 was made by the petitioner only to show that in spite of the restrictions pointed out by the defendant in the suit, on what restrictions?
Eco-sensitive restriction.
Due to the suit land falling within eco-sensitive zone, there are
Not transferred.
what you wanted to prove?
I wanted to prove that commercial activities is permissible in eco-sensitive zone.
The commercial activities is permissible in eco-sensitive zone. Stop. He therefore submits that the trial court has erred in rejecting the petition number 1187 as well as 1189 filed by the present petitioner, and therefore prays for setting aside the said orders, setting aside the order dated 16/8/2024 to the extent it rejected the prayer made by the petitioner in petition number 1187/2023 and 1189/2023. Stop. By invoking its powers under Article 227 of the Constitution of India. On the other hand, learned counsel for the respondent, Mr. R. Ali, has objected to the prayer made by the petitioner in this civil revision petition. Stop. He submits that the aforesaid petitions were filed by the petitioner before the trial court at a belated stage after examination of the plaintiff's evidence and when the matter was fixed for examination of defendant's evidence. He submits that as during the cross-examination of PW1, it has been admitted by the PW1 that restriction, he admitted that
That restriction and also that later was exhibited exhibit 10. During cross examination.
as it was admitted by the plaintiff as PW1 that the alienation of land falling within eco-sensitive zone is prohibited. However, only to fill up the lacuna later on, the aforesaid petitions were filed. He further submits that as regards petition number 1189/2023 filed by the petitioner, the trial court was correct in dismissing the same as the present respondent has never disputed the existence of said agreement to sell. He submits that even the counterclaim of the present respondent is based on the said agreement to sell, and therefore the question of disputing the same does not arise. He also submits that the trial court was also correct in dismissing the petition number 1187/2023 in as much as the holding number 9 the shop having holding number 9 in the schedules,
9 option.
9 shops. Holding number is 9.
Separate holder.
Total 9 holding numbers.
Okay, the shops, 9 numbers of shops over the schedule, over the suit land, having separate holding numbers. 9 numbers of shops over the schedule land has never been, existence of 9 numbers of shops over this schedule land has never been denied by the present respondent. And the trial court, he submits that trial court was also right in observing that the said shops are not the subject matter of the dispute, as the suit is primarily a suit for specific performance of contract. And to decide the issues framed by the trial court, the evidence intended to be produced by the trial court are not relevant. And therefore, he submits that invoking the jurisdiction of this court under Article 227 of the Constitution of India is uncalled for. I have considered the submissions made by learned counsel for both sides and have gone through the materials available on record. Remaining part I will dictate in chamber. Today itself.
I was also about to take leave, my lord, for another matter. Deeply advised.
Item 6.
May please give me note. Lordship, here my MSc claim case was dismissed, Lordship, for filed beyond the 6 months period of limitation, Lordship. 2 weeks only was a delay and I filed a delay petition that was rejected, Lordship. So my humble prayer is this order dated 9/4/2024 in page number 20, Lordship. I have challenged that one. And in this respect, Lordship, I'm filing this two set of judgments, Lordship.
No, before we go to judgment, This CRP is for,
For rejection of the petition, my petition number 978/24, Lordship, in page number 20, Lordship. My petition is 18 and 19. And 20 is the rejection order of learned tribunal, Lordship.
your prayer for condonation of delay was
Rejected.
rejected by the tribunal. And against that you have filed
This CRP IO, Lordship.
under 227.
Yes, Lord.
Why not under 115?
Because this is a specific order only for that rejection.
No, by that rejection order, the claim case was not registered. It has finally disposed of. Therefore, my query is, when was the rejection order?
9/4/24, Lordship.
When have you filed this?
After 2 weeks only,
Within the
Beyond the
period
6
of
months.
limitation?
after 2 weeks of the limitation, 6 months, Lordship.
No, again. 9/4/2024. 31 August. This has to be under 115. 227 is not maintainable. You have remedy under 115. Only question is it is subject to law of limitations. To escape law of limitation, you cannot come under 227 when there was remedy under 115.
Lordship, in last, there are 2, 3 cases, Lordship. I went through, then it was converted into CRP IO, Lordship, 227, Lordship.
Where?
Here, Lordship, and immediately here the notice is also issued, Lordship, and in the delay condonation they have received, Lordship. I'm just showing this. And the case was remanded back, Lordship. I filed and one on 5 and 227, Lordship. Then the.
No, you don't show what happened in other case.
Yes, Lordship.
You praise the merit of this case. What has happened in other case is not relevant.
No, the same issue, Lordship. Same type issue, Lordship. The delay condonation, Lordship, and filing within the period of limitation, Lordship.
In this CRPIO, IA আছে নেকি? You have filed earlier condonation of delay
Yes,
application.
Lordship. Yes,
That
Lordship.
delay was condoned.
Lordship.
Okay.
The respondent said appeared.
Then
Also, notice will go, then I'll not mind, Lordship.
this has been treated under 115 only,
Notice.
because in 227 question of delay is not there.
Yes, Lordship.
Question of delay does not arise. Okay, we'll issue notice.
Yes, Lordship. No problem.
Heard Mr. A.R. Agarwala, learned counsel for the petitioner. Though this application has been filed by the petitioner under Article 227 of the Constitution of India, read with Section 115 of the Code of Civil Procedure 1908, it is treated as an application under Section 115 of the Code of Civil Procedure. It also appears that in the connected IA, the delay in preferring this instant CRP has already been confirmed. Issue notice to the respondents. The petitioner shall take steps for issuance of notice upon the respondent by speed post as well as by usual mode within 7 days from the date of this order, returnable on 27th February, list accordingly.
Order, item 7.
My please. Can you take up the IA 16? This application I filed for seeking leave for withdrawal of the Wakalatnama. The reasons are stated in paragraph.
You have informed the other,
Yeah,
informed the petitioner.
I have sent a notice. It is at page 14 of the IA.
No.
25
Where is the notice
at page 14.
and the postal receipts?
Postal receipt is not annexed.
Have you sent this notice?
Yes, my lord,
By what means?
by post.
Then you have to submit the postal receipts to show that.
Oh, it is not annexed. Notice will be issued in the IA. I'll take steps for sending the IA.
No, we'll allow you to your application. You just show the post, submit the postal receipts.
And a date may be fixed.
This IATLIKI, interlocutory application number 16. This interlocutory application has been filed by the, what is your name?
All of I'm the counsel there and along with my colleagues.
Petitioner for withdrawal of Wakalatnama by the present set of lawyers engaged by the petitioners for reasons set out in the said interlocutory application. Learned Counsel, Mr. What is your name?
All of
Oscar has submitted that the counsel for the petitioner had also issued notice, legal notice to the petitioner on 25/7/2025, and he also submits that same notice has been sent by way of registered post. However, he has not produced the postal receipts. Stop. He, Learned Counsel, therefore seeks leave of this court to produce, to file an additional affidavit to produce the postal receipt of the notice sent to the petitioner. The prayer is allowed. Let this case be listed of Guddev.
17.
Lord, I am appearing for respond number 4, 8, and 20 and 22.
17th February. Show, what is your name?
K. Uddin, my lord.
Show the name of Mr. K. Uddin, Learned Counsel for respondent number
4, 8, 20, and 22.
4, 8, 20 and 22 are present. And Mr. T.R. Gogoi, Learned Government Advocate, appears for
49 to 51.
49 to 51,
17 February, my
17th February.
Lord.
lord.
Item 8.
May please your lordship. Lordship, as per the office note, if my lords comes to the office note of 11/12/2025, I was supposed to take steps. Office note 11/12/2025.
Yes.
I was supposed to take steps upon one gha, one nga, one sa, and one cha. Although I have taken steps on one unga, cha, and sa, but gha I have not taken because she has expired. I am told I have instruction for that. And regarding other, that like one unga, one sa, and cha, I as regards one unga, your lordship, unserved notice has been received by the section as of yet. No notice of unserved notice has been received. Regarding sa and cha, there is insufficient address, so I have to take fresh steps, I guess, yeah.
Yes.
Appearing only on behalf of respondent number 2, Your Lordship.
Heard Mr. VP Singhal, learned counsel for the applicants. Also heard Ms. S. Chakravarti, appearing for respondent number 2.
Two.
It appears from office note dated 11/12/2025. The notice sent to respondent number 1 within bracket unga, UNGA लिखिबो, and 1 sa, and 1 cha, CHA. Have returned without service. These 3 have returned.
Yes, my lord.
Learned counsel for the petitioner submits that he may be allowed to take fresh steps on the aforesaid respondents. The prayer is allowed. The petitioner shall take steps for issuance of notice on the aforesaid respondents by speed post within 7 days from the date of this order. Returnable on 26th of February.
Right.
List accordingly.
May it please your lordship. We have filed this IA for refund of statutory default. As the matter has already settled.
Disposed of.
Yes, Lordship.
Matter, the MSC appeal has been disposed of.
Lordship, MSC appeal not there. It was, IA, in IA it was settled. MSC appeal remained as filing number, Lordship. Lordship, the matter was settled in the year 2019.
Matter is disposed of in Lok Adalat.
Yes, Lordship. And it was disposed before Honorable Justice S.P.
Okay. Heard Miss, what is your name?
Musahari, Lordship.
Heard Miss S. Mushahari, learned counsel for the applicant. Applicant insurance company. Applicant insurance company. This application, in this interlocutory application has been filed in connection with MSC appeal bearing filing number 14923/2018 filed by the present applicant. No, but this is something for corrections of.
Yes, Lordship. In that order, statutory depot which has to be refunded to New India Insurance, but mistakenly it has, in the order it was reflected that that amount may be given to respondent number 1, Lordship. That correction is required. It may come before appropriate bench, Lordship.
Oh, then it will have to go to that bench.
Yes, Lordship.
Kili last line. has this interlocutory application has been filed by in connection with so and so by the insurance company praying for correction of the order dated 9/3/2019 passed by a coordinate bench of this court within bracket Honorable Mr. Justice K.R. Surana bracket close. Stop. The registry she also prays for listing this matter before the appropriate bench. Registry to do the needful and list this matter before appropriate.
Highly obliged.
Item 10.
May I please, your lordship? We have I filed the affidavit in opposition today. I don't know if it is, perhaps it's not come on record, your lordship, against their petition.
Item 11.
May it please, your lordship. It's for my lord, violation, my lord. There was an injunction order granted by this honorable court. The violation of that order, my lord. That is the injunction order on page number 11. That is the order, first order, my lord. First order, my lord. 10/5/2023.
You have anything to say?
Your lordship, we would like to file our affidavit in opposition.
Written objection.
Yes, sir.
Let them file.
In the meantime, my lord, a report from the concerned police station, because we have lodged an affair in this regard, my lord. That should be called for, my lord.
What FIR?
Because they have violated, my lord, and were violated, and there is some physical assault on me, my lord. And therefore, if I filed immediately I have lodged an affair before the concerned police station, that is Bhangar police station. I have annexed it, my lord.
Oh, what was the injunction order?
Injunction order was not to construct. My lord,
They started constructing.
yes, there's a photograph I have with geotagging, my lord. There's a photograph here annexed, my lord.
Okay, let them file objection. The FIR has been filed in respect of the offense which was committed, assault, assault.
The assault as well as the violation, my lord, which was took place, my lord. And the police has, my lord, reached the spot, my lord, and thereafter, my lord,
For violation, you have to file FIR or you have to file this application,
this application, my lord, this application and the affair was because of there was some, my lord,
assault.
assault and the construction also. So first, my duty is to inform the police, my lord.
Okay. Third, Mr. Shiladitya, learned counsel for the applicant in IA number 62. 62.
Applicant as well as appellant, my lord.
This interlocutory application has been filed by the applicant / appellant under Order 39 Rule 2A of the Code of Civil Procedure, alleging breach and willful disobedience of order dated 10/5/2023 and 14/6/2023 passed by this court in IA civil number 1030/2023. By the respondent. Stop. Mr. What is your name?
A. Bhuya, lordship, I'm appearing on behalf of Mr. N. Bharali.
Mr. A. Bhuya, learned counsel appearing on behalf of Mr. N. Bharali, learned counsel for the respondent. Praise for allowing the respondent to file a written objection against the application filed by the petitioner. The prayer is allowed. Let this matter be listed
2 weeks, lordship.
on 20th of February. And what happened to the RSA?
RSA is for hearing, my lord. For final disposal, my lord, RSA it was fixed for hearing, my lord. In the meantime, my lord, this development was happened, my lord.
You are not ready for hearing.
First, this I has to be disposed of, my lord.
Why first that has? This is also fixed for hearing.
This was fixed for hearing, but today it is listed for orders only, my lord.
But IA was also fixed for hearing on 27/1/2020. This RSA.
Yes, my lord. In the meantime, my lord, this development was happened, my lord.
No, that may be taken up together with RSA.
On 20th, my lord, both the RSA and the present.
RSA লিখিব parties একে থাকিব. List this matter for hearing on 22/2020.
20, 20, 22 0.
20. 13 or আগত দিও. 12th February. Both the cases on 12th February.
12 February.
Next week.
Can it be on 17, my lord?
17 February.
17 February. Obliged.
Standing at 4.
আহিছে objection তো আহিছে. Yes.
But here, against the injunction that order, we have come before this honorable court under 227.
Injunction passed by which court?
By the court of Munship number 1.
He has raised the question of.
Yes, my lord. Now,
First, you address the question of maintainability.
yes, maintainability, my lord. Now that order 43 rule R, rule 1R, whether that was yes, order 43, rule 1R, an order under rule 1 and 2, rule 2A and rule 4, so and so, so and so, so and so. An appeal shall lie. An appeal shall lie from the order under the provision of section so and so, so and so. R is that if any order is obtained under order 39, rule 1 and 2, an appeal shall lie.
Yes.
Yes. Now we have come here by 227. Now this order, which was passed by the trial court in Milk case number 305/22.
Where is the impugned order?
Yes, at page 62. Page 62. Ex parte order, my lord. Page 72, the relevant part. May I read?
Now what you want to show?
Now here, this is the order passed by the trial court expertise. That is also not finally disposing of. Now whether this is an order to which an appeal lie, or whether we cannot come under 227 because this is the final order. Under application made. under-
While issuing notice to you,
That is, this is the day, my lord.
okay.
On the day of notice, this order has been passed.
This is an expert ad interim injunction.
Yes, my lord. As per the interim order has been passed
Yes.
in the injunction petition, my lord. So
Yes.
that's why we have come for 227.
Why it is not covered under 43 1R?
43 1R, my lord, naturally it will be, if it is the petition is disposed of. That's my lord there. If it is.
No, you are not correct. You are not right. Though you can
Yes, my lord.
try to persuade this court.
Yes, my lord.
Your submission is if it is finally disposed of, only then 1R.
Only then, my lord, then appeal will lie.
What is the basis of your submission?
Basis is that this is the interlocutory order, my lord. The interlocutory is not a final order in the injunction petition. Of course, my lord, the final order of injunction petition will march later on in the decree of the suit. But this is the order passed on the first day without, my lord, issuing the notice to the defendant and state the matter. So we have applied, my lord, this power under 227. Yes, of course, after disposal of this case, of this petition under order 39 rule 1 and 2, an appeal lies, of course, my lord. But whether all orders, any orders passed under 39 1 and 2,
Yes,
whether appeal lies under
that is my
order
query to
43
you.
or rule 1R.
Because 1R says an
Any-
order under rule
The
1.
only order under rule 1 and 2.
Any order. It does not say final order. You want
Doesn't,
to,
yes, doesn't say final order, but an order under rule 1 and 2.
okay,
order.
okay. Yes, Mr.
That's only the technical, my lord.
Yes, Mr. Sharma. You are not withdrawing it.
Because we have to go there again, of course, my lord.
Yes, Mr. Sharma.
Because in any way, this way or that way, my lord.
What's your sign? The order was passed under order 39 rule 1 2. It is the expired injunctions. Injunction is passed under order 39 9 rule 1 2 of CPC, my lord. Order 39.
That day you cited some judgment of full bench. Mr. Sharma,
My lord.
you have cited some ruling earlier on last occasion.
Ruling or rule, my lord. I am submitting the rule. I am bringing out 30, order 38. It is 39.
No, you are not producing any authority in support of your submission.
It is 39, my lord, order. Order 38. Order 39, my lord, it is. It is under order 39, temporary injunction, my lord. Rule 1. A temporary injunction, the case in which temporary injunction may be granted. It is there now, temporary injunction. When in any suit, it is proved by affidavit or otherwise that any property in dispute is in danger of being wasted, damaged, or by aliened, or any part of the suit wrongfully sold, execution of the decree, or that the defendant threatens or intends to remove or dispose of his property with a view to defending his creditor, and that the defendant threatens to dispose of the plaintiff property, etc. The court may by order grant a temporary injunction to restrain such act, make such order, and the other order or for the purpose of staying in preventing the wasting or damaging the alienation, sale, removal, or disposal of any property. On those grounds, the court can grant injunction. After granting ex parte injunction, court can issue notice, Rule 3, Order Final Rule 3, when granting injunction, court to direct notice to opposite party. The court shall, in all cases, except where it appears that the object of granting the injunction would be defeated by any delay before granting an injunction, court can notice of the application for the same to be given to the opposite party. Because after if the matter is urgent, the court by granting injunction may issue notice under Rule 3, my lord. So under Order 39, Rule 1, injunction is granted ex parte without issuing notice, and after granting injunction, notice can be issued under Rule 3, my lord. That is it is the case in hand now. My ex parte injunction was granted, and thereafter notice was issued to the opposite party to show cause as to why the injunction granted should not be made absolute, my lord. This is the case here. Now, my lord, under this order, what can be done here? Of see the Order 43. Order 43 provides for appeal from order. That means from which order under CPC the appeal shall lie, my lord. The appeal from orders and appeal shall lie from the following orders under the provisions of section 104, namely, that is so and so. Now the 1R, my lord, the 43 1R, an order under Rule 1, Rule 2, Rule 2A, Rule 4, Rule 10 of the Order 39. Rule 1, Rule 2, it is the order passed under Rule 1, my lord. Ex parte injunction order was passed under Rule 1, my lord. So apparently against that order, appeal shall lie, my lord. No revision, my lord. Under submission, it has meant that it is interlocutory order. If it is interlocutory, then no revision lies. Under interlocutory order, no revision lies, my lord. So it is apparently appealable order. They have remedy. They can file appeal before the civil judge senior division Sunitpur, my lord, against that order. The appeal will not lie, my lord. It is very clearly mandatory provisions, my lord.
Okay.
So what affidavit they have submitted, they have not stated a single words against the maintainability of the petition. Your lordship, I may read it if your lordship allowed. The correspondence, it will be affidavit.
Okay.
Copy of the affidavit. Your lordship, kind of see the para 5. Others paras are 11. Para 5, my lord. That with regard to the statement made in para 3, 4, and 5 of the above objection, the deponent denies the same, which are inconsistent and contrary to law. The deponent begs to state that the above CRP has been filed challenging the order that 15/12/2000 for past ex parte in Mills case number so and so arising out of case number so and so by the court below, after having arrived at the improved findings is holding that claim made by the respondent are genuine and as such did not discuss the 3 golden principles of granting temporary injunction. Further, it is an evidence that Ms. J case number so and so has not been disposed by the order that on the above CRP as such has been filed in the interest of justice. Also, not a single word against the maintainability of the case. What I have submitted in my petition that it is appealable under Order 39. So appealable under Order 43, Rule R of the CPC, not revisions under Section 227, my lord. So except that nothing is given in this affidavit, the challenging my convention,
Just one submission.
that no appeal is live, my lord.
Just my senior counsel, my lord, has submitted that Rule 3, Order 39, Rule 3. If he submits that way, then Order 39, 43, 1R doesn't apply. There is no mention of Rule 3. Appeal lies only against Rule 1 and 2. Order 39, Rule 1 and 2, not 3.
It is an order, of Rule 1, my lord.
Then the senior counsel submitted my other Rule 3.
39.
Rule 3, whatever he has just submitted
Okay.
just now, grant to
Heard Mr. B. Sinha, learned counsel for the petitioner. Also heard Mr. K. Sharma, learned counsel for respondent number 1. This application under Article 227 of the Constitution of India has been filed by the petitioners impugning the ex parte ad interim injunction order granted by the Court of London, Munsif number 1, Sonitpur, on 15/12/2022 in Miss J case number 305/2022, arising out of title suit number 284/2022. Stop. At the outset, learned counsel for the respondent has raised an objection regarding maintainability of the instant civil division petition under Article 227 of the Constitution of India. He submits that the impugn order dated 15/12/2022 is an order of ex parte ad interim injunction granted under Rule 1 of Order 39 of the Code of Civil Procedure. And as such, it is amenable to appellate jurisdiction of the appropriate appellate court under Order 43, Rule 1 within bracket small r of the Code of Civil Procedure. He submits that as an appropriate statutory remedy is available under the aforesaid provision, the invoking of supervisory jurisdiction under Article 227 of the Constitution of India is not called for, and the instant civil division petition is not maintainable. On the other hand, opposing the plea, learned counsel for the petitioner has submitted that the impugn order is an ex parte order and has not finally disposed of the Miss case. That is the application under Order 39, Rule 1 and 2. He submits that the orders mentioned in Rule 1 within bracket small r of Order 43 of the Code of Civil Procedure is pertaining to a final order only. And since the impugn order is in the nature of an interlocutory order, same is not covered under Order 43 within bracket 1 within bracket small r of the Code of Civil Procedure. He therefore submits that the plea of non-maintainability of the instant civil division petition does not have any force in it. Stop. I have considered the submissions made by learned counsel for both sides and have gone through the materials on record. Stop. It is no longer res integra that the jurisdiction under Article 227 of the Constitution of India has to be sparingly exercised by this court. Only in cases where the court whose order has been impugned in the said proceeding has exceeded in its jurisdiction and has committed patent illegality and which has caused miscarriage of justice. Stop. Where an alternative statutory remedy is available for a party, the jurisdiction under Article 227 of the Constitution of India is not to be exercised. Bare perusal of the impugned order would show that the said order has been passed by the trial court under Order 39, Rule 1 and 2 of the Code of Civil Procedure. And any such order is amenable to appellate jurisdiction of the appropriate appellate court under Order 43, Rule 1R of the CPC. Stop. Bare perusal of the aforesaid provision would make it clear that the order mentioned in Rule 1R of Order 43 does not distinguish between, does not discriminate between a final order or an interlocutory order. What is required is that the said order is to be has to be an order under Order 1 or Order 39, Rule 1, Rule 2, Rule 2A, or Rule 4 or Rule 10 of the said order. As the impugned order is apparently an order under Order 39, Rule 1 and 2 of this CPC, this court is of considered opinion that this application under Article 227 of the Constitution of India is barred by the said provision. The appropriate remedy for the petitioner is to approach the appropriate appellate court under Order 43, Rule 1 within bracket R of the Code of Civil Procedure. For the aforesaid reasons, this civil division petition IO is dismissed.
Lordship, I apologize for the intrusion, but in item number 11, your Lordship was pleased to fix it on the 17th. On the 17th, Lordship, the leading senior counsel is having some difficulty. I'm praying that it may be fixed on the 19th. I've taken the consent of the
90.
appellant also.
Item number?
11.
Item number 11, 19.
Obliged, Lordship.
Hearing item 12.
Lordship, the conducting counsel, Mr. A. Satta, is unable to prepare today, Lordship, due to some personal.
You are praying for adjournment.
On the other day also, the same prayer was made. And your Lordship was fixed the matter as first item. Today also because it is a ejectment suit of a land measuring 508 acres, and they are occupying the land. And I own both the courts below. And now they are trying to delay the progress of the appeal in various ways.
There has been a subsequent development, Lordship. Actually, the land has already been attached for non-payment of the provident fund.
Non-payment of?
Provident fund.
Non-payment of provident
That
fund
is a-
and the
that is a very-
ejectment decree is quite distinct and different. That is their lookout whether they pay or provident fund amount or not. That
I'm
is-
just praying for 1 week, Lordship.
No, why today it is not possible?
He has some personal difficulties, so he
The
wouldn't.
council. But
Conducting counsel, Mr. A. Satta.
on last occasion also you prayed for adjournment. Yes, Mr. Sharma.
On 3rd of February or
3rd of February, okay.
3rd or 3rd of February.
3rd is okay. What is your name?
L. Sanktam, Lordship.
L.
L. Sanktam. Can it be on 9th, Lordship?
Heard Mr. L. Sanktam,
9 is motion day.
learned counsel for the appellant L. Sanktam, learned counsel for the appellant. Also heard Mr. A.C. Sharma, learned senior counsel assisted by Mr. R. Sharma, G. Bhardwaj, learned counsel for the respondent. Learned counsel for the appellant has prayed for an adjournment on the ground of personal difficulty of the conducting counsel for the appellant. Stop. Learned counsel for the respondent has objected to the grant of adjournment on the ground that on last occasion also the prayer for adjournment was made by the appellant, which was granted by this court. Stop. However, considering the submissions made by learned counsel for the appellant, the prayer for adjournment is allowed. Let this matter be listed on
3rd of February.
Let it be on
3rd
3rd
of February. Let it be on 3rd of February. That's it.
3rd of February.
There is an interim which may be done.
Yes?
There is an interim order which may be done.
There is no interim. Huh?
The interim order shall continue till next day. 3rd February.
It will be listed as first item.
No. On that day, you may make prayer.
Well, today it is as a first item, your lordship.
But today we have seen the fate, what has happened to the first item. Okay. Let the matter be listed as first item on 3rd of February.
Item 13.
First hearing item. You have, what has happened? After 19 June, it is coming. June, it is coming for the first time.
Lordships. Lordships, matter was heard on 12/6/25, Lordships. And
Why it was not listed on 19 June? Because now everything has vanished. After almost,
Lordship, in fact,
you have prepared written gist,
yes, that.
both of you.
Lordships.
You can brief me.
Lordship.
Lordships,
Where is your written argument?
I have submitted Lordships, written argument with citation, Lordships.
Written argument section.
I am on behalf of Srikant Pathak. Srikant Pathak.
Respondent or Asani. Respondent side has also prepared.
I filed lordship and later on when I checked, it was misplaced actually.
You have extra copies.
I
Right?
have one extra copy today. I was
Okay.
informed that it was misplaced. There is a call from the registry also. It was misplaced, so kindly furnish us one. So I've taken one today.
Yes, what is your case?
May please, your lordship. My lord, these two checks, lordships. 5 lakhs plus 5 lakhs, lordships. Is purported to be issued by me to the complainant, lordships. Actually, the checks, two checks never been issued, lordships. And accordingly, lordships, the learned trial court passed the judgment that I have to pay the compensation of rupees 18 lakhs and 6 months. Lordship, jail, lordships. Thereafter, lordships, I have approached before the Honorable Session Judge and Honorable Session Judge reduced the amount from 18 lakhs to 13 lakhs and from 6 months to 3 months. Lordships, against that lordships, I have approached before this honorable court challenging the order of judgment and order passed by the session judge, lordships. And similarly, lordships, this complainant also has approached before this honorable court challenging the same order, lordships.
Of reduction,
Against the reduction,
reduction.
I am for setting aside the order, lordships.
Okay.
Now, my stand is that I have not issued the check, lordships. This complainant, he was my friend, lordships. I had a textile shop at Maligaon, lordships, and he used to come, lordships. This, I trusted him, I believed him, and accordingly, he was sitting frequently at my shop, lordships. But 2 checks, lordships, it was signed by me, lordships, purported to be stolen. Of course, I have not reported before the police station. And lordship, thereafter, lordships, it was produced before the concerned bank, lordships. And as it was dishonored, lordships, against that, this case came up, lordships, under section 138 of NI Act, lordships. Now, as I have not issued the checks, lordships, so my stand is that I am not liable to pay, lordships. And also regarding that, he took the stand that I have enforced for loan, lordships. But he never said either in the complaint case or in the affidavit that he has paid the money, lordships. He has never said that he has paid the money. Only statement is there that here I have approached to him for some amount, lordships. So as I have not paid any, I have not issued the checks, lordships, so I am not liable to pay the amount, lordships. And also, lordships, at that time, lordships, in 2025 May 2025, it was heard at length. And thereafter, lordships, it came up on 12/6/25. That day also, lordships, matter was heard, and honorable court directed to submit a substance, lordships, and accordingly, this I have submitted my substance with some citation, lordships. My stand that I am not liable to pay, lordships,
Because you have not issued the check.
issued the check.
How the trial court has dealt with your submissions? How trial court deal with your submission that
Lordship, there also I took the stand that in the complaint case, lordships, no affidavit, no verification was there in the complaint case. But that was overlooked, lordships, in spite of taking the stance. And lordships, that from my side, lordships, no evidence adduced, lordships, but when statement of defense was there, at that time, stand was there that I have not issued the check,
you have not deduced any evidence?
not deduced, lordships.
Then what is the wrong in the appellate court's judgment?
Lordships, this honorable appellate court, lordships, that here I have taken the stand that no affidavit and no verification in the complaint case, lordships. And also, lordships, that that my brother lordships, one brother, Sukan Pathak, he was also purported to be issued a check to the same person. And accordingly, lordships, this this complainant filed a case under 138 lordships. And in that lordships, this Sukan Pathak, my brother lordships, he was acquitted lordships. And as he could not submit any ITR, income tax return, or any document that he has paid the money to me, he could not show. He could not produce before the honorable court. So there was no transaction lordships. And accordingly, the appellate court lordships ought to have interfered the matter lordships.
Yes, anything else?
Lordship. That is my.
Yes. Yes.
Lordship, that the check was.
You will also be filing a written gist of your submissions.
Lordship,
You have prepared it.
I'll submit it.
Okay.
Today I'll submit. Lordship, what is submitted before this learned senior council, before this honorable court, that he never paid the check. I'd like to draw Lordship attention to page number 19 of the CRP 439. CRP 439. By the next 4.
Yes.
Lordship. That is in fact the reply to my demand notice. I'll read out, Lordship. Sir, under the instruction and full authority of my client named Srikanta Pathak, son of so-and-so, address so-and-so. I do hereby give the reply of your notice addressed to me, to my client on 15/11/2008. My client has gone through the contents made in the notice and understood the same and come to the conclusion that your client misconstrued, misguided, and misrepresented before you and thereby wrongfully briefed you. The check number 504104 was the self check and not the bearer check, and thus your client converted the check number 504104 to the bearer check. Besides, my client never wrote the amount date on the said check. Hence, your client himself attracted offenses relating to the documents and the documents to property and to property marks contained in chapter so and so of the Code of Criminal Procedure. Further, my client never wrote down anything on the check number 504112, and your client was directed by my client for unilateral security purpose. My client never directed to write and present the same to the concerned bank of your client, and as nothing was written on the check and only directed to keep for security reasons, hence the said checks are said to be in blank under section 16 of the NI Act, and the said checks are not negotiable instrument under section 13 of the said Act. I hereby demand your client through you that the checks held with him
should be returned to my client directly at his earliest convenience, and notice issued requesting on 11 as 25/11/2008 under his instruction should be withdrawn forthwith, and failure to do so, I have specific absolute instruction of from my client to institute criminal as well as civil proceeding against your client before the competent court of law, whereby your client would face dire consequences for payment of damages, costs of suits, proceedings, and incidental expenses. So it is the admission that the checks were being issued, be it for unilateral security purpose and for other and whatever other reasons, Lordship. Now, if checks were not issued and there are instruction from his client that to initiate criminal and civil proceedings against the complainant, that is not being done, thereby also admitting that the checks were being issued, Lordship. Then, Lordship, another averment being made, submitted before this honorable court, that the complainant never paid money. He did not make any averments of payment to the respondent, Lordship, accused person. Now, Lordship, I have filed additional PW1 evidence, that is probably page number 49 of the LCR.
49.
Evidence of PW1 at page 49, but additional evidence, probably have to check that one.
Trial court record. What you want to show?
Lordship, in fact, I have made my averment. Can I, if I can read out in my additional evidences, PW1?
Yes.
Can I read out, Lordship?
Yes.
At paragraph 3, Lordship, of in my additional evidence on affidavit, that I know the accused person since late 1990s, and after the accused person had approached me for a loan of 10 lakhs sometime around 2004. I don't remember the exact dates and and in cash between 2004 to 2007, with trust that built up with him throughout the years, I could not pay this big amount to the accused person at a time. The accused person received the amount from me with promise to return the same on demand. This is what I have stated in my additional affidavit at PW1, Lordship. Lordship, now I fully
Yes.
the checks were being returned for insufficient funds, and I fully agree with the trial court before the SDGM judgment. But what happened in the appellate court, Lordship, I'll read out. That is CRP 439 at page 49.
Yes.
Yes. Also at paragraph 35, if I can read out, Lordship. The learned court has, while passing the judgment, observed that the checks were valued for rupees 10 lakhs and compensation imposed was rupees 18 lakhs and for imprisonment of 18 months. I am of the view that considering the check amount of rupees 10 lakhs for the interest of fair justice, compensation of rupees 18 lakhs appears to be higher side, and sentence of imprisonment of 18 months is also appears to be in higher degree, as it was not commercial transaction. Now, while issuing check and while a check is being dishonored, I do not find any differentiation between the commercial transaction or a regular transaction. That is the only ground what the appellate court said thereafter, instead of 18 lakhs, I find it proper to reduce the amount to 13 lakhs and sentencing the accused for 18 months to simple imprisonment of 3 months. In default of payment, compensation, simple imprisonment of 2 months. Except I have come before this honorable court only because of that. Otherwise, that I fully agree with the trial court and the appellate court orders, observations, lords, except this one, paragraph 31. It was reduced only on that ground because it's not a commercial transaction. And rest of my arguments in bullet points, I'll submit. Lords. If anything, lords, I can submit, lords, if any query is there.
Okay, you submit your written gist.
Lords.
Heard. একেলগে রাখিব। Heard Mr. R. Sharma, learned counsel for the revisionist in criminal revision petition number 439/2019 and respondent number. State is a party in this.
Lordship. State,
And respondent in
court
criminal revision petition number 542/2022. Also heard Dr. N. Deka, learned counsel for the No, go to all of Ultai Koredivo. Petitioner in criminal revision petition number. No. Your petition is
4-2 lordship.
542 and respondent in 439. I got to. Heard Miss Dr. N. Deka, learned counsel for the respondent in criminal revision petition number 542/2022 as well as petitioner in criminal revision petition number 439/19. Both the learned counsel have also submitted the written gist of their respective submissions. Hearing concluded, judgment reserved.
Lordship, any judgment, no date shall be fixed for judgment, Lord. Obliged, Lord.
Wait for some people.
No, please allow. My lord, I am for the sole respondent in this matter. On the last two dates, the appellant was absent. On 4/11/2025 and again on 4/12/2025. On 4/11/2025, I had filed a.
For the appellant,
Yes, your lordship. I'm appearing on behalf of Mr. V.P. Das.
yes. What is the submission?
He is unable to conduct the case today, your lordship, due to some personal difficulty.
You are seeking, this is an old case.
This is
Yes, sir.
2012 and the execution has been stayed. I have one in the other two courts, in the court below. This is the second appeal and I have.
We'll allow your adjournment prayer by vacating the stay.
Your lordship, such a decision has to be taken, without.
No, on last occasion also you remained absent.
And the occasion before that also, my lord, on 4/11/2025, the day on which my IA application for expeditious hearing was allowed.
A short date may be given your lordship, then your lordship may vacate if any.
Okay, one chance hearing.
I leave it to your lordships. please.
Okay. Heard Mr. Arm Mishra,
A Mishra,
A
on
Mishra,
behalf of Mr. P. P. Das.
appearing on behalf of Mr. P.P. Das, learned counsel for the appellant. Also heard Mr. S. Borua,
As Borja.
learned counsel for the respondent. Learned counsel for the appellant has prayed for an adjournment on the ground of personal difficulty of the conducting counsel for the appellant. Stop. Learned counsel for the respondent has opposed the grant of opposed the said prayer on the ground that on earlier two occasions also the appellant sought for adjournments which were granted. He further submits that in this case, the respondent had also filed an application earlier for expeditious hearing of the instant second appeal, which was allowed by order dated 4/11/2025. However, in spite of this said order, the appeal could not be heard till date due to the delaying tactics of the appellant. Stop. After I have considered the submissions made by learned counsel for both sides. Since it is an old pending regular second appeal of the year 2012, it is to be disposed of expeditiously. It has to be disposed of expeditiously. However, considering the ground stated by learned counsel for the appellant, one last chance is granted to the appellant side. Let this case be listed when?
On 3rd of February, hearing day Tuesday.
Let this case be listed on 3rd of February.
Deeply obliged.
Obliged.
16.
Wait, please, Lordship. Here in this case, Lordship, I am appealing for respondent numbers 1 to 5, Lordship. Records of two cases, two MAC cases was called for. Only record of one case has been received. Lordship, kindly see order dated 27/11/20.
Which case?
Lordship, the records of MSC case number 889 of 2010 has been received.
Received, Lordship.
However, Lordship, the record of 1594 of 2010 has not been received.
Lordship.
Why?
But both are analogous cases, so for the hearing purpose, Lordship, the LCRs will be required.
So record may be called for other,
Mr. S.P. Sharma, S.K. Sharma,
SP Sharma, Lordship.
S.P. Sharma, learned counsel for the appellant. Also heard Mr. M. Talukdar, learned counsel for respondent number
1 to 5, Lordship.
1 to 5, as well as Ms. S. Mushari,
6 to 9, Lordship.
appearing for respondent number 6 to 9. It appears from office note dated
27/11/20, Lordship. Lordship, order dated 27/11/20.
office note dated 21/1/2023 that both are from Silchar,
Silchar, Lordship.
that which one has been received?
Lordship, 889 of 2010 has been.
that records of MSC case number 889/2010 has been received by this court. However, another MSC case which was analogous to the said case bearing number
1594 of 2000.
bearing MSC case number 1594/2010, which was also called for, has not yet been received. The registry to issue a reminder for the same. Let this matter be listed on March of the
Last week of February.
on 10th of March after receipt of the aforesaid record.
Obliged.
17.
Take up the matter at 2, my lord.
Yes,
Can you take up the matter at 2 p.m. my lord?
two,
2, my lord.
two,
2, my lord.
two, we have fixed matters. Why?
Senior PK Roy Chaudhary, my lord, in leg, my lord.
We'll take it in the second half after,
My lord.
we'll take it up in the second half.
Aye.
Or should we adjourn it?
No, my lord. 4 times they have taken.
Okay, we'll take it up in the second half.
All right.
Item 18 and 19.
Well, this is a long pending how as well as CFP. And the for this proceeding is against the order of the trial court granting injunction.
CRPIO is,
My lord, subsequently there has been
who has filed the appeal?
my lord, the same side by the.
You are the appellant. And why CRP?
Subsequently, after injunction, your lordship, they have filed a petition under 151, saying that they need police help because the injunction is violated. Without any due diligence or anything, your lordship, police help was ordered in the civil matter, your lordship.
Thereafter,
Thereafter, there was an order passed that police should interfere in the matter, and we have challenged that order by filing a CRP.
thereafter some stay was granted.
Stay was granted.
My lord, this matter, my lord, both this matter may be disposed of, my lord, with a direction to the trial court to make inquiry about the status of the land, my lord. They are challenging my sale deed, and we claim that their sale deed, their sale deed is a fraudulent document. And that too, they have filed the title suit on 9/11/2023.
No, Mr. Sikdar. We will not be going into the other issues. We'll be examining order 39, rule 1 and 2
Yes,
order
ma'am. Yes, ma'am.
and the 151 order.
Yes, ma'am.
If those orders require interference of this court,
Yes, madam. Yes, madam.
we'll decide.
Then, my lord, lordship may kindly have a look at the impugned order. Impugned order in their how in the.
Let the petitioner submit.
Yes, madam.
First, the first appeal against order, your lordship. Lordship, if I may start at 2, your lordship, which will take some time. I'll narrate the facts as well, your lordship.
Okay.
It's almost.
We'll start after lunch.
Hello.
At 2. At 2, 2 aru ki ase? Okay, we'll decide which one to take first. At 2.
Yes, madam.
May I please, your lordship?
At the outset, my sincere apology for mentioning at this stage, Lordship. In as well, item number 12, Lordship has fixed the matter on 3rd February, Lordship.
12,
12, Lordship.
yes.
Lordship, on that day, Lordship, learned council is Sattar has some personal difficulty. We have agreed, both the parties have agreed. On Lordship may fix the matter on 10th. Both the parties will have agreed.
Item number 12, 10 तारीख है नहीं. Okay.
Highly, Lordship. In time, there is in time.
No, no. Earlier, जितो दूतात fix আছে. Cost list. बक itu mati दो.
Item 23.
Wakalatnama has been found.
That's what
It is still in the section, so
happened sometime, Lord.
we may proceed ex parte. I have already heard both of you,
Yes.
but since the owner is not there, at his back, we will be passing orders against his interest. Therefore, your plea has to be carefully considered. What is your plea that there is breach of?
No, Lordship, thing is, notice was sent, he appeared, councillor representing him, and this is not ex parte, Lordship, this is not at his back.
This will be ex parte.
He chose not to argue, that is a different issue.
That will be an ex parte when the matter is called on for hearing. Nobody appears.
Ex parte, I understand, Lordship, is there is no Wakalana, no representation, nothing like that.
That is
Okay.
not, I think it is not correct understanding. Ex parte means when the matter is called on for hearing, the parties are not present. Though,
Then Lordship wants to give a date so that the advocates appear.
no, I don't want to give any date because
But Lordship, this is pay and recovery, both the.
I just want to consider your plea again, that whether is it a case of pay and recovery?
Yes, yes,
Whether you took before the
yes,
tribunal the plea that there is a breach of.
yes, yes. That's why I told, the tribunal had rejected our on the ground that we had not mentioned it in our written statement. That day I showed Lordship our written statement, which I have in annexed, Lordship, page 15 of my memo of appeal, paragraph 12. Where that plea was taken, that because Lordship, in the policy, there are too many
But which ground has been violated?
Lordship higher. Lordship I mentioned in the last order.
No, you
Yes.
have not mentioned it in your WS.
No, no,
In
Lordship,
your-
there are too many grounds of violation, Lordship. Policy, it is sometimes for DL, it is sometimes for permit, it is sometimes for.
Therefore, this has to be considered properly. What are the requirements of order 8?
Lordship,
How you have to,
whether first Lordship will have to consider whether order 8 is applicable in MSC
it
cases.
is, even if it is not applicable strictly.
But then we have taken, thank you. But then Lordship, we have taken that plea in our para 12. And Lordship, if it is to be heard, today I didn't come prepared for full-fledged hearing, Lordship. I thought only the Wakalatnama is required, so because Lordship passed the order last time.
Okay, no, what is your ground in this appeal?
That it was used for hire, the document which was exhibited by the claimant themselves, the charge sheet, in that it is mentioned that it was used for hire, and we adduced evidence that since it was used for hire, there is violation, and I have also annexed the insurance policy at page 18, Lordship.
But
That-
the trial, the tribunal rejected your plea because it held that in WS you have not specifically mentioned.
Lordship, I'll read paragraph 12.
Yes.
That with regard to statement made in paragraph 14.
Page number?
Page 15, Lordship, of my memo of appeal.
Yes.
14 to 17 being matter of records, however, the answering OP insurance company denied the same. In this connection, the OP number 3 states that the liability, if any, will be subject to the fulfillment of all necessary conditions provided under the MB Act 1988. The
OB number 3 is also not liable to indemnify the owner if there is any violation, Lordship.
Yes.
Any violation of the policy
If
condition.
there is any violation,
Yes,
you have to show where is the violation,
we showed that
where.
by adducing evidence, Lordship. There are too many. There can be violation of DL. There can be violation of permit. There can be violation of over gratuitous
I
passenger.
am putting query because the council is absent. Therefore, I am putting more queries.
Lordship, that is why it is.
Is it not
violation-
required for you to specifically mention in your WS?
So we have to, for the whole policy, we have to mention one. That is not the law. In when there is a DL violation or gratuitous
No,
passenger.
no, let me understand it properly.
Yeah.
In your policy, there are many stipulations.
Yes,
If there is violation of any of them, you are not liable to indemnify. That is the,
that is the any.
any of them.
Yes.
Listen to my query. Suppose there are 15 policy condition, 15 stipulations. If any of it is violated, you are not liable to indemnify. Is it not required on your part if there is a violation? Now, in this case, there is a single specific violation which you are alleging, that the vehicle was used for hire purpose. It was rent on hire or some. So is it not required on your part to specify in your WS that this is the violation so that the owner come prepared with his defense?
No, Lordship, owner already knows. He gave the vehicle. The person, he had died, Lordship, in this case. So he had given the vehicle on hire. That he already knows it. If he has to take a plea on that, he has to deny. And Pappu, Lordship, that's why I mentioned the judgment in Pappu.
No,
It is for the,
don't go to judgment.
yes, Lordship. No,
First.
I'll go to the law, actually, not judgment, but law
Not
is
law.
that, Lordship. It is the owner who has to first prove that his vehicle was in this condition. It was driven by DL. It was that has to be fulfilled. Then only the responsibility will be of the insurance company to prove that there was violation, Lordship.
No.
First, the owner has to prove that. Yes, Lordship wants to ask something.
This is a case of claimant. Claimant has to prove that he is entitled to get compensation.
Claimant proved the charge sheet,
Ex-
Lordship. Claimant proved exhibited the charge sheet, and in that it was mentioned it was taken for hire. They have hidden, Lordship.
So
There
you
is a
have
bit
take-
of
you have
fraud
to-
also involved in this.
Is it not required for you to take a plea in your written statement that as they have taken rent on hire, this is a violation of a policy con?
Any violation, that is how the.
That is
because,
my-
Lordship,
that is
it
my
a
query.
Civil, it is not a civil case, Lordship, in which we take defense of every year. It is a summary proceeding. MSc cases are summary proceeding. We cannot take these proceeding in the standard of a civil case, Lordship. They are summary proceeding, and in summary proceeding, whatever the things come up, we take defense. They claim their compensation, we take defense. Otherwise, Lordship, for every claim case, a police officer has to come and adduce evidence because he has given a charge sheet, he has given a FIR, he has given a. It doesn't happen. We accept it. That is why, Lordship.
Don't-
That strict
I
procedure.
am not on that. When you want to escape liability of indemnifying, mainly by taking plea that if there is a violation, you have taken in your WS a plea that if there is a violation, I am not, without showing specifically as to what is that violation. Is it required or not? That is my query.
Lordship, this is sufficient. This is sufficient because otherwise, Lordship, then the question will come. There are so many violations. They can happen so many violations, Lordship. And those we came to know only later on when the charge sheet was exhibited. They have hidden. There is an element of fraud also in this case, Lordship, because they have hidden. The claimant has not mentioned it. The owner has not mentioned it. Only in the charge sheet it has come and they exhibited it. Claimant exhibited it.
Okay. when you pointed out to the tribunal that this policy condition has been violated,
When we
in your
raised
argument or in evidence?
evidence.
Yes. Where is the evidence?
Evidence, Lordship. Right.
What evidence?
Lordship, as per the charge sheet, paragraph 10 and 11, Lordship. But for the record, I have to again go. Achha. The insurance company examined Dijen Datta, who is the administrative officer of the company. He has admitted that the offending vehicle was under.
What is my query is, since we are proceeding ex parte against the owner.
Lordship, we can take against step, Lordship, no issue. We can take
No,
because
no. Why to take step? In spite of receiving the notice,
Yes,
they are not appearing.
but Lordship, now Lordship is asking about giving benefit to the owner.
No,
because
I am not. Why have you taken that impression that I am giving benefit? I am putting queries because we will be passing an order in absence of somebody who will have to indemnify. So this court has to be clear on all facts. Only I am not disclosing what decision I am going to take. Had the owner remained present here, perhaps he would have asked these questions. Therefore, I am putting.
Lordship, he could have cross-examined our witness. He did not. He chose not to cross-examine. If he had those questions, and after using evidence by the insurance, then also he had time to.
In appeal, listen, you have to make me understand.
Yes.
I am not understanding a particular thing. You have to make me understand. The tribunal has awarded the compensation to the claimant, making you liable. In spite of your submission is that in spite of the taking plea that by you that there was a violation of a policy condition. And the tribunal rejected your plea on the ground that you have not specifically taken that plea in your written statement. So against that order of the tribunal, you have preferred this appeal.
Yes.
So in this appeal, you have to show to this court that tribunal was wrong. You have taken such and such plea.
Yes.
And your defense was known to the other side.
Yes. It was known, Lordship. That is
Now,
why I have
now
used this
you have shown me paragraph number 17,
12.
12 of your written statement, where you have taken a general plea.
Not liable to indemnify the owner.
If there is a violation,
If there is any violation.
if there is any violation, without mentioning therein as to what violation you are alleging, because according to your submission at that time you were not aware. You came to know about that violation only when the claimant adduced his evidence, when charged.
Not only that, when we do our investigation, Lordship. We did our investigation.
But not at the time of filing written statement.
That was not done. But then any violation, that is why any violation is mentioned, Lordship. So the owner has to say that
So this
there was
court,
no violation.
no, this court has to decide whether is it sufficient for the insurance company to take that much plea in the written statement to shift burden to the owner.
Lordship will give a date, I'll bring out certain judgments. Because
Yes.
that is how we do. Lordship, it's in other cases also, written statements are written that way only.
No. What is happening in what way, that will not impress me. You have to impress by logic.
Because Lordship, what is the in
Le-
default?
le-
Lordship, the owner is getting in default.
Now, let me put queries. We are deciding to proceed ex parte against the owner. Because this is not an appeal where claimant, only because claimant is not objecting to your plea, the appeal may be
No,
allowed.
that is not, because even if claimant doesn't, I have all my judgments in
Yes,
ye.
you
But
have
the
to-
thing is, we are ready to pay to the claimant, because the claimant advocate is also learned, Lordship. He knows what is the law. what is the settled law. It is not that he has not done his research and he has not. So the Lordship is saying that since the claimant advocate is agreeing to, no, Lordship, he has done his full research. And after that only he has submitted. On the first day, he did not submit that. So he has done his research, and that's why, because the case is pending from 2016, Lordship.
That also does not answer my query.
Yes, Lordship.
My query is,
Ready to write down, Lordship.
yes. Let me put my query.
Wait for 1 minute.
Heard Miss R.D. Majumdar, learned counsel for the appellant. Also heard Mr. P.P. Botakur, the learned counsel for respondent number 1, as well as Mr. R. Deka, learned counsel for respondent number 2 and 3. Learned counsel for respondent number 4. By order dated 22/1/2026, this court had directed the court master to verify from records as to whether any wakalatnama has been filed by respondent number 2, though by the same order it was observed that the cause list shows that the respondent number 2 have engaged counsel and their names were also reflected in therein. Stop. Today, the court master has informed this court that the wakalatnama, that the respondent number 2 has filed wakalatnama in this case and had engaged Mr. B.P. Bora, Mr. P. Dutta, and Mr. R.S. Ronghan as their counsel. The names of said counsel are also reflected in the cause list today. Today also, the respondent number 2, who is the owner of the offending vehicle, is not present when the matter is called on for hearing. This court therefore directs this appeal to proceed ex parte against respondent number 2. Stop. Stop. During the course of submissions made by learned counsel for the appellant, Ms. R.D. Majumdar, it has been submitted that the insurance company is not liable to pay the compensation to the claimant, and it is the owner of the offending vehicle who is to be made liable. She submits that the insurance company, however, is ready to pay the compensation subject to the condition that it may be allowed to recover the same from the owner of the offending vehicle. Stop. She submits that the same plea was taken before the insurance company same plea was taken by the insurance company before the MAC tribunal. However, the said plea was rejected by the tribunal by holding that in the written statement
para 19 of the judgment.
was not pleaded by the insurance company that the offending vehicle was used for commercial purpose, which is violation of the policy condition. Stop. Learned counsel for the appellant submits that in the written statement, where is your written statement?
Page. It starts from the.
In the written statement filed by the insurance company in paragraph number 2.
12.
Paragraph number 12, the insurance company has specifically pleaded that the insurance company within bracket opposite party number 3 is not liable to indemnify the owner if there is any violation of the policy condition and statutory provisions of MV Act as well as Insurance Act. She submits that later on it has been established in the proceeding before the tribunal that there was a violation of policy condition of not allowing the vehicle to be hired or hired or
Hire or reward.
hired or reward. Stop. On this, a query was posed by this court as to whether it was necessary for the insurance company to specifically plead in its written statement as to what was the violation which is alleged to have been committed by the owner of the offending vehicle, of the violation of the policy, insurance policy alleged to have been committed by the owner. A line to পড়ি দিয়কচোন।
Paragraph number 12, insurance company has basically pleaded that the insurance company violation which is due to
The insurance company has, in paragraph number 12, the insurance company has specifically pleaded into Nagor Purapa.
bracket opposite party number 3 is not liable to indemnify the order if there is any support of the provisions of NPA as well as
If there is any violation of policy conditions and statutory provisions of the MV Act. On this, a query was posed by this court as to whether the plea of violation of stipulations, any violation of any stipulation of the insurance policy has to be specifically made there in the written statement. Before same could have been considered by the Motor Accident Claims Tribunal. She submits that the manner in which the written statement has been filed is sufficient to bring to the notice of the tribunal, the Motor Accident Claims Tribunal, as well as the opposite parties and the claimant regarding the violation which the insurance company has pleaded in its written statement. She, however, submits that the provisions of Code of Civil Procedure are not applicable to a proceeding
All provisions.
Also,
Applicable, not all.
all provisions of Code of Civil Procedure are not strictly applicable to a proceeding under MV Act, to a claims proceeding under MV Act. She further submits that she may be granted some time to answer to the query posed by this court. When?
19 lordship. Because too many cases have been hearing on these days,
Issue
or as lordship.
19th February. No, not 19th as part third matter. We will take it up as first hearing, 19th key bar,
9.
Thursday. We will take it up as first hearing item. Let this matter be listed on 19th of February as first hearing item.
Only thing, lordship, I might have to take an adjournment, but it is not yet finalized because I might have to go for a mediation training outside. But if I'll inform them also beforehand. It is not yet finalized, but
Which date to which date you have?
no, they have just tentatively given
Which date?
from 20 to 25, but it is not yet finalized.
Then we can take a date after 25
Okay.
instead of
Then lordship, because
26. Oh.
no, I hear no. March or দিব লাগিব তেতিয়াহলে.
let it be in March first week,
5th of
5th of March.
5th of March.
5th of March as part third matter.
I think 18 and 19.
Yes. Mr. Chaudhary, you are not there in this case. Oh, you are in the. Okay. Yes.
Lordship, first the appeal against the order, Your Lordship. So first, before going to the appeal directly, I'll just place the brief facts. I was the plaintiff of the suit, Your Lordship. Title suit number 149/23. The plaint is starting from page 14, Your Lordship. And the prayer is at page 18. So basically, there is a plot of land, Your Lordship. The plot of land measuring 2 bigha, 2 katha and 5 lesser, which is the schedule A, Lordship. Schedule B plot of land. Out of the schedule B plot of land, the schedule B plot of land belonged to 4 persons jointly, Your Lordship. All 4 brothers, Siddiq Hussain, Abdul Hussain, Atawar Rahman and Bilal Hussain. 4 persons.
Who are you?
I did not come into the picture as of now, Your Lordship.
Okay.
4 persons, Siddiq, Abdul, Atwar, and Bilal Hussain, were the joint owners of a plot of land measuring 2 bigha, 2 katha, 5 lessons.
2 katha?
2 bigha, 2 kathas, 5 lessons.
Yes.
245 lessons, Your Lordship. Out of that 245 lessons, 64 lessons, that means 3 katha, 4 lessons, was sold by Abdul to one Hafiz Maqbul in the year 1979.
Okay.
And then Hafiz sold it to Jaldar Ali in the year 1982 by registered sale deeds. All this.
Okay.
And thus remained 181 lessons after this, that transaction, Your Lordship. 1 bigha, 4 katha, 1 lesser. Out of that 181 lesser, that 1 bigha, 4 katha, 1 lesser, Atawar Rahman, another co-owner of that plot of land, Abdul sold that previous portion and Atawar Rahman sold it to another Bilal Hussain in the year 1992.
Okay.
And I purchased it from Bilal Hussain subsequently. Thereafter, the contention of, I was the plaintiff, Your Lordship. my vendor had purchased a portion of 2 katha and 10 lesa only. 50
Who
lesa.
are you, Siddiq Hussain? Original plaintiff?
Original plaintiff, Your Lordship, Jil Hussain and others, Your Lordship.
Okay, Jil Hussain.
Jil Hussain. There are 8 plaintiffs, Your Lordship. We purchased it from one Bilal Hussain, and Bilal Hussain purchased it in the year 1992.
Okay.
Portion of 2 katha 10 lesas only out of the total plot of land. In the year 1994, Your Lordship, after purchasing, I've been possessing my 2 katha 10 lesas only. Thereafter, I discovered recently that in the year 1994, after my vendor had purchased that plot of land of 2 katha 10 lesa only, the entire plot of land of 2 bigha and odd was sold to the defendants. So I filed the title suit.
Who sold it?
All the 4 brothers, Siddiq, Abdul, Atwar, and Bilal, together, after parting with a portion of the land to my vendor and then my vendor to me, the entire plot of land was again sold to the defendants.
Okay.
In the year
You have prepared a chart showing who sold when.
not very fresh, Your Lordship.
Okay. You mentioned, have you mentioned?
Yes, I have mentioned that.
Okay.
They have purchased in the year 1994. So when I discovered this fact, I filed the title suit, which is at page 14, praying for declaration that I am the absolute owner of the Schedule A land. Schedule A in the next page at page 19, Lordship will find 2 katha 10 lesas. At my portion only. Since my vendor purchased the plot of land of 2 katha 10 lesa and sold it to me, so I prayed for a declaration that I am the owner of 2 katha 10 lesas, Schedule A land, and they are not the owners of the Schedule B land, which includes my Schedule A land. Schedule B, they have purchased subsequently the entire plot of land. So they cannot be the owner of my plot of land as well. So I prayed for a declaration that the defendants are not the absolute owners of Schedule B, and their sale deed dated 8/9/1994 should be cancelled. This was the prayer, Your Lordship. And I prayed for permanent injunction restraining the defendants and their main and agent to dispossess me from my plot of land, 2 katha and 10 lesas only. Situated thus, they appeared, Your Lordship. They have filed their written statement. There was no counterclaim or anything. And the defendants filed the injunction petition, stating that
in your suit.
In my suit. Their contention is that they have 2 nephews who are not parties to the suit, and they have a shop room in their portion of the land. And because of this suit, by virtue of filing this suit, we are obstructing them from running those shop rooms. That was the contention of the defendants in the injunction petition.
Okay.
And they prayed for injunction. Injunction was granted. I'll go through the 3 principles here also Lordship. Injunction was granted. After granting of the injunction, they filed a petition under section 151, stating that they need police help because even after getting the injunction, they were not allowed to run the shop, so they needed police help. They did not resort to the regular provision under the CPC. That is another thing, Your Lordship. And then on the next very date, police help was also allowed, Your Lordship, and police was directed to interfere in the civil dispute. So this was the situation, Your Lordship. Now coming to the impugned judgment, Your Lordship, of the injunction. It starts at page 44. 47, from page 47 is the portion where prima facie case was discussed by the trial.
Yes, page number.
Page number 47. Page number 44 onwards, the judgment starts, Your Lordship. Initially, the facts are laid down. And page 47 is the discussion on prima facie case.
Yes,
Your Lordship, I may read your Lordship. Page 47.
yes.
Now let us see whether there is a prima facie case in favor of the petitioners. The opposite parties in their written statement had contended that the temporary injunction of the petitioners' defendants are not maintainable as they did not file any counterclaim in the main suit. Now, as per provision 39(1)(a) of CPC, any party can file temporary injunction petition and the defendant as such can also file a temporary injunction petition. Now, the petitioner's side at the time of hearing has relied on the decision of Honorable Karnataka High Court in the case of so-and-so, wherein the Honorable Karnataka High Court has held that the defendant can file temporary injunction petition against the plaintiff without filing a counterclaim when the defendant's claim to relief arises out of the plaintiff's cause of action or incidental thereto. Now, in the instant case, the Schedule B land of the temporary injunction petition is the subject matter of the plaint, and as such, the defendant's claim to relief arises out of the plaintiff's cause of action and incidental thereto. Hence, in light of the aforesaid judgment and going by the provision of Order 39 Rule 1A, it is found that there is no impediment in filing this temporary injunction petition by the petitioners despite being the defendants in the main suit. Now, the petitioners' defendants in their temporary injunction petition has stated that the petitioners had purchased Schedule B land of the petition and have constructed their residential houses therein and have also constructed two shop houses in the northeastern portion of the suit land, wherein the son and nephew of the petitioners are running the business of stationery shop in the name and style of Arzu Enterprise and one medicine shop, Hassan Medical Store. But the opposite parties, on the dint of a false sale deed purchasing the land, are trying to dispossess the petitioners and are obstructing the petitioners from opening the said shops. Now, the Honorable Supreme Court in a catena of judgments have held that the term prima facie means the first sight, at the first appearance or on the face of it. And it is not to be confused with prima facie title, which has to be established on evidence at the trial. Prima facie case is a substantial question raised bona fide, which need investigation and a decision on merits. So in the instant case too, it can be seen that the petition alleges that the opposite parties are trying to dispossess them from Schedule B of the petition and are obstructing the petitioners from opening their said shops basing on an alleged false sale deed. The petitioners, in support of their contentions, have submitted the copies of Jamabandi, registered sale deeds, and photographs of the suit land. So it can be seen that there is a matter to be adjudicated between the parties, and as such, there is a tribal issue. In other words, to be precise, there is a prima facie case made out. Hence, there is a prima facie case existing. So the first golden principle of granting injunction of that existence of a prima facie case is found affirmative. Here, Your Lordship, I would like to submit that since the suit land is a Schedule A land, which is a part of the Schedule B land, Your Lordship, they have projected their son and nephew has a shop room, has two shop rooms, in the entire suit land which they have, and we have sought for cancellation of that, Your Lordship. But that could not enable them to get an injunction over the entire suit land, which also includes our suit land, Your Lordship, which is under our possession. I'll come to this issue again, Your Lordship. Now coming to the balance of convenience. The next. Now the petitioner, as discussed above, has made out a prima facie case. The opposite party has contended in their written statement that Siddiq Hussain, Abdul Hussain, Atwar Rahman and Bilal Hussain had jointly sold a total plot of land measuring 2 bigha, 2 katha and 5 lesa under dag number so and so, katta number so and so in favor of the plaintiff defendants, namely them. The petitioner defendant, namely Nurul Islam and Khazeda, by registered sale deed number so and so dated 8/9/1990. But the delivery of possession of the total plot of land could not be given to the petitioner since the plot of land measuring 3 katha 4 lesas and plot of land measuring 2 katha 10 lesas of dag number so and so were already sold out by Abdul Hussain and Atwar Rahman out of the total plot of land so and so under dag number so and so through 2 number of separate registered sale deed in favor of Hafiz Maqbul Ahmed and Bilal Hussain. This Bilal Hussain is my vendor, Your Lordship. So after such transfer, a plot of land measuring 1 katha 11 lesas remained under the dag number so and so, khatiyan number so and so. So subsequent transfer of the total plot of land measuring 2 bigha 2 katha 5 lesa by Siddiq Hussain, Abdul Hussain, Atwar Rahman in favor of the petitioner's defendants pro registered sale deed number so and so is illegal, void, inoperative and is liable to be cancelled. Now both sides have made their own contentions, but both sides are required to prove their respective contentions in the main suit by adducing evidence. As of now, it is only to be seen that whether the 3 golden principles for granting temporary injunction, that is prima facie case, balance of convenience and irreparable loss, are there or not in the favor of the petitioners claiming the temporary injunction petition. Now, as discussed above, a prima facie case is found to exist in favor of the petitioners. Now, as of balance of convenience, it can be seen that the petitioners has prayed for a temporary injunction to restrain the opposite parties, their main agent, from dispossessing the petitioner defendant from their purchased land and obstructing the running of their business in the shop houses situated in the Schedule B land. Now, if no temporary injunction is granted and the opposite parties, their main agent, are allowed to dispossess the petitioner's defendants from running their business on the shop house situated in the Schedule B land, then it will prove a great loss to the petitioners on being deprived of their home and earning their livelihood, leading to irreparable loss. While on the other hand, granting of temporary injunction till disposal of the main suit will not cause any harm to the other side. So on the second golden principle of granting temporary injunction, of that of balance of convenience, stand in favor of the petitioners. Again, Your Lordship, the court did not consider that the suit land that I am claiming rights over is 2 katha 10 lesa, which is a part of the entire 2 bigha and odd plot of land, and they have sought an injunction over the entire plot of land. And by guise of the injunction, Your Lordship, they are also trying to disturb the peaceful possession of the plaintiffs over the 2 katha 10 lesa only. So the balance of convenience, while deciding the balance of convenience, the learned court did not look into this aspect, Your Lordship. They have pleaded in their miscase, Your Lordship, the injunction petition, that there are 2 shop rooms of the son of the defendant and one of the nephew of the defendant. They are not parties. No document regarding those shop rooms were produced before the trial court. We have objected about the existence of such shop rooms, Your Lordship. We have denied it. However, in this, after filing this FAO, an affidavit has been filed by the defendants here, Your Lordship, affidavit in opposition, which at page number 82 and 84 shows the trade licenses, because we have pleaded that they have just pleaded that we have to, my nephew and my son, not the parties, have 2 shop rooms in the plot of land, and they are being objected to, and they are not being allowed to run the shop rooms. And on the mere statement, Your Lordship, it was believed to be true and injunction was granted. Now coming to page 82, Your Lordship. these documents were not there before the trial court, in spite of the fact that they ought to have filed these documents. Rezaul Karim, Your Lordship, they have stated the name of the shop, though in their injunction petition, Arzu Enterprise, Rezaul Karim. Surprisingly, Lordship, this is of the district Borpeta, Your Lordship. Village Longla, PO Longla, and Borpeta. This suit land is situated in district Bongaigaon, Your Lordship, in a different village, in a different district altogether. And the next trade license, which is at page 84, Asan Medical Stores. These two names, shop rooms names were mentioned in the injunction petition. This is also of the same village of Barpeta, Your Lordship. So these two shop rooms in my submission are not the shop rooms present in the same suit land. The suit land, Your Lordship, as it is seen from the schedule, is in a different village, is in a different district altogether. The name of the shop rooms are also there, written there, but the documents which have been produced before this honorable court show that these are shop rooms situated elsewhere. Now, coming back to the judgment, Your Lordship.
Yes.
The next irreparable loss. The court has already found out that there is a prima facie case. My submission is, though the prima facie case they have projected was shown to be in favor of the son of the defendant and a nephew of the defendant, which is a separate cause of action altogether, if at all there is a shop room. Second, balance of convenience.
They are not the parties.
They are not parties. Then balance of convenience, on the decision of balance of convenience is, in my humble submission, it is urged as because the court did not consider that I am claiming ownership and declaration of right title interest over a portion of land measuring 2 katha 10 lesas. And the defendants, though they have not filed any counterclaim, they have stated that they are the owners of entire 2 bigha and odd plot of land, which includes my 2 katha and 10 lesa.
Where is the operative part of injunction? What was
Lordship, if I made it irreparable loss, and only then.
page number?
It is page 51, Your Lordship.
Yes.
Irreparable loss. Now, as for the irreparable loss as discussed above, if no temporary injunction is allowed as prayed for by the petitioner, and the opposite party, their men and agents are allowed to dispossess the petitioner's defendants from Schedule B land and are allowed to obstruct the petitioners from running their business on the shop house situated in Schedule B land, then it will prove a great loss to the petitioners on being deprived from their home and earning their livelihood, leading to irreparable loss, while on the other hand, granting of such temporary injunction till disposal of the main suit will not cause any harm to the other side. So in the event of not granting any temporary injunction, the petitioners will suffer irreparable loss. So the third
Who filed this order 39 petition?
The defendants,
Not the nephew and,
not the nephew.
okay.
So the third golden principle of granting temporary injunction, that of irreparable loss, also stands in favor of the petitioners. Now, since the 3 golden principles of granting temporary injunction, that is prima facie case, balance of convenience, and irreparable loss, are found to be in the favor of the petitioners, so this court finds it a fit case to grant temporary injunction. The petition number so and so filed by the petitioner's defendants under Order 39 Rule 1A is as such allowed, and the opposite parties, that is their men, agents, etc., are restrained from dispossessing the petitioners' defendants from Schedule B land and are also restrained from giving obstruction in running their business on the shop houses in Schedule B land till disposal of the main suit. So the discussion and observations made in this order are only for the sake of disposing the aforementioned temporary injunction petition and will have no effect bearing on the main suit. So this Schedule B land, the learned court has overlooked the fact the Schedule B land they have been granted a injunction over the entire Schedule B land, which also contains the Schedule A land, Your Lordship. And Schedule A land, which we are praying for confirmation of right title interest, declaration of right title interest by that we have purchased through registered sale deed, is also a part of the Schedule B land. And by virtue of this injunction, Your Lordship, they have been trying to dispossess us from our Schedule B land, and by projecting that we are hampering their injunction over the entire Schedule B schedule land. This was the situation. Thereafter, coming to the CRP, Your Lordship, as a continuation. Immediately, we have challenged this by filing this FAO, and there was an IA. In the IA, we had prayed for. In the FAO, there was an IA and there was a stay, Your Lordship. Subsequently, we got the stay. In the CRP, at page 59, annexure 7.
The IA has been disposed of.
IA, there, it was stay till returnable date, Your Lordship. It was extended from time to time.
Yes.
So the injunction order was passed on 29/6/2024. And the IA and the petition under section 151 CPC, which is at page 59 in the CRP, annexure 7. Annexure 7.
Yes.
It was filed on 23/7/24, Your Lordship. Less than even 1 month of that injunction, Your Lordship. They have projected that, Your Lordship, it is at page. At page 60, para 3, they have stated, Your Lordship, after obtaining the copy of the order dated 29/6/24, the petitioner on 2/7/24 went to open their shop. The petitioners, they are stating that the petitioners here, Your Lordship, whereas their contention is the shop room belonged to their nephew and their son. The petitioner on 2/7/2024 went to open their shop situated on the B schedule land in presence of leading person of the locality, but the opposite party and their ill inmates obstructed the petitioner from opening the shop house. The petitioner has shown the copy of the order dated so and so, but the opposite party threatened the petitioner by saying that they will neither obey the court order nor allow the petitioner to open the shop house to run their business, and thereby violates the order dated so and so passed by this honorable court. This was their contention, Your Lordship. Whereas the actual fact is that after obtaining the injunction, they have tried to dispossess me from my 2 Katha and 10 Lecha, which is a part of their entire Schedule B plot of land, Your Lordship. Be that as it may, Your Lordship, we filed an objection to this. We have denied all these things, Your Lordship. And this honorable court on 24/9/2024 passed the impugned order in the CRP, which is at page 67. Annexure 9. And on the mere submission, on the mere statements made by them in the petition, has proceeded a relevant portion is at page 70, Your Lordship. Previously, the contentions of both the parties were reflected, Your Lordship. And it was also reflected at page 67, para number 3, Your Lordship. Page 67, the order starts.
Yes.
There, it was also reflected that we have filed the FAO, which is the serial number was given, and we have prayed for some time since it was yet to be admitted, yet to be numbered. It was also reflected. And under such circumstances, your lordship, coming to page 70, your lordship, in the third paragraph from top, if I may read from there, your lordship.
Yes.
Now it can be seen that the aforesaid petition number so and so filed by the petitioners alleging violation in the injunction order by the OP is accompanied by an affidavit shown by one of the petitioner. Moreover, I see no reason to disbelieve the petitioners as they been not restrained by the opposite party in opening the shop in Schedule B land. Had they been able to open their said shop and run their business freely, then why would they have preferred this petition unnecessarily when they well know that they have to bear the police protection expenditures in case of being allowed police protection? Now, the learned trial court wide order dated so and so passed in Miss case number so and so has allowed temporary injunction petition of the petitioner and restrained the opposite parties, their main agent, etc., from dispossessing the petitioner's defendant from Schedule B land. Here I will pause and say Schedule B also included Schedule A land, which is under my possession, and had also restrained them from giving obstruction in running their business on the shop houses situated in Schedule B land till disposal of the main suit. Now, when it has come to the record that the petitioner is facing obstruction from the OP in running their business in the Schedule B land, so it is incumbent upon this court to see that its order is not violated. Hence, in the given circumstances, considering all aspects, deeming it proper, I allow the petition number so and so filed by the petitioner. Accordingly, allow police aid to be given to the petitioners in opening their shops in Schedule B land in order to run their business. The officer in charge of the concerned police station is directed to give police protection to the petitioners to ensure that no obstruction is given by the opposite parties or their main agent, etc., to the petitioners in opening their shops in Schedule B land in order to run the business on receiving the required police protection expenditures from the petitioners. Petitioners to deposit the required police protection expenditure as per existing rules. Let a copy of this order be sent to all concerned. Without ascertaining whether there was any shop room by the name as projected, this order was passed, your lordship. And the documents of the shop were not there before the trial court, which came on records only before this honorable court after filing this FAO, and it shows that those shop rooms under the same name are situated in a different village under a different district. Another aspect of this matter, your lordship, as I was the plaintiff of the suit and they were the defendants, I prayed for permanent injunction as well as a temporary injunction over my plot of land, your lordship. My temporary injunction petition is not here, your lordship. There was no temporary injunction. I prayed for permanent injunction over my plot of land over 2 Katha 10 lesses, your lordship. They have not filed any counterclaim. As such, there was no question of any permanent injunction prayed by them. Whether any temporary injunction can be granted without there being any prayer of permanent injunction, this is an aspect that has to be looked into. And in this regard, I would like to submit a decision of this honorable court, Gadadhar Burman versus Ranendra Mohan Pal. Reported in 1998, 1 GLR 383. 1998, 1 GLR 383, which lays down the settled proposal, your lordship, that temporary injunction cannot be granted in absence of any permanent injunction in the main suit, your lordship. So whether in absence of any permanent injunction prayed for by them, can a temporary injunction be granted in their favor? This is one limb of my argument.
Which para? You are relying.
Lordship, the relevant paragraph.
Yes. Later on you point out.
Lordship, I'll point out the paragraph numbers.
Okay.
I have it somewhere. This is one judgment that I am relying on, and another limb of my argument would be, Your Lordship, that even though the court has
Yes.
opined that there is a prima facie case, the court has failed to, the learned trial court has failed to consider that the prima facie case that has been projected was in favor of a nephew and a son of the defendants, Your Lordship, and not by the defendant themselves. So without them being a party, that would have been another cause of action altogether, Your Lordship. So the prima facie case projected is not a prima facie case per se, Your Lordship. The balance of convenience, in the balance of convenience, Your Lordship, the court have failed to consider that the entire Schedule B, over which they have prayed for and got an injunction order, Your Lordship, also included my portion of 2 Katha 10 lesser, which is under my possession as per my plaint, Your Lordship. So granting injunction over the entire plot of land does not amount to balance of convenience in respect of my possession over my plot of land, because after obtaining this injunction, Your Lordship, they have tried to dispossess me and disturb my peaceful possession over my plot of land, Your Lordship. I was the plaintiff in the suit. Irreparable loss also, Your Lordship, since I am already in possession of a portion of land measuring 2 Katha 10 lesser, for which I have prayed for confirmation of possession and declaration of their sale deed in respect of the entire plot to be cancelled, Your Lordship. It could not have been, injunction could not have been granted in their favor, because it would ultimately cause me irreparable loss if I am dispossessed from my portion of 2 Katha 10 lessers, Your Lordship. So these three are my basic submissions. And that apart, Your Lordship, the trial court did not have any document to see whether there was any shop room as projected by them. Only statements that they have, their son and nephew has 2 shop rooms. Secondly, as to whether we have obstructed them in opening or running any shop room, there has been merely statements and denials by us. There has been nothing to show that they have been running 2 shop rooms over the scheduled land. And now, in the affidavit in opposition filed before this court, the trade license which are annexed show that these 2 shop rooms, the names were mentioned in the injunction petition itself, Your Lordship. But the names, now the documents show that these 2 shop rooms exist in a separate district, in a separate village, Your Lordship. These have nothing to do with the suit land in question.
And in CRP, why police help should not be granted?
Lordship, in CRP, Your Lordship, there is CPC provides a course, Your Lordship, for violation of injunction. Under 151, there are catena of decisions, Your Lordship. In civil matters, generally police interference should not be encouraged, Your Lordship. When there is a specific course which provides adequate remedy in case of violation, and if I may read the provision, Your Lordship.
No, 2A is there.
2A is there, Your Lordship.
But
For 2A, the court has to be satisfied that there is a violation. If there is a violation, Your Lordship, there are remedies laid down there, Your Lordship.
but that is for imposing punishment and
Punishments.
attachment.
So
But police help is also provided there in
2A.
civil rules and orders.
Under 151, why did they choose 151, Your Lordship? Immediately, within 1 month from this order of injunction, Your Lordship, the moment police interference is there, Your Lordship, we are already in possession of a portion of 2 Katha 10 lesser, Your Lordship, out of the entire plot of land. What they are trying with this injunction order, the defendants, without there being any counterclaim or any suit from their part, Your Lordship, they are trying to dispossess us from our small portion of 2 Katha 10 lesser. And this police help in a civil matter, Your Lordship, would further cause harm to the plaintiffs, Your Lordship. So before resorting to police help, the learned court ought to have resorted to two-way, your lordship. And for two-way, they ought to have shown that actually there has been a violation of the order. In the order under challenge in the CRP, your lordship, there are statements by them that we have violated the order, injunction order. There are denials by us in the objection, your lordship. Your lordship. There is no foundational fact as to how and when we have violated that injunction order, your lordship. So straightway granting police help without ascertaining as to whether there was actually any violation. Under 151, they have filed this petition. For two-way, there has to be a satisfaction as per the provision, your lordship. Whether.
Okay, okay.
That's all.
Yes, Mr. Singh.
And as submitted by my seniors that if it is to be remanded back to the court to consider all this aspect, that can be done in my submission, but these things had to be considered by this court, by the trial court, your lordship, while granting any injunction or not.
Yes, Mr. Sikdar.
My lord, we have filed affidavit in opposition in the appeal. Lordship, for a moment, kindly have a look at the sale deed of our sale and their sale deed. My lord, we purchased land in the year 1994. Lordship may kindly have a look at page 72. My lord, annexer B of my affidavit in opposition. My lord, my sale deed. We purchased land in the year 1994. Lordship got my sale deed, my lord, translated person at page 72.
Yes.
My lord, kindly have a look, my lord, down below the schedule and boundary. We have sold the entire land under DAG number 372 of Kotian number 196, measuring 2 biga, 2 katha, 5 places situated at village Simlabari, part 1 under season Gram Revenue Circle, PS, and sub-registered office Abhaipuri in the district of Bongaigaon, which is bounded by north boundary of Barbara district. My lord, it is a land bordering 2 districts, my lord. My land is bounded by Barbara district and south Jeldar Ali Munshi, east Abdul Barik, west Borpeta. The land measuring 2 katha, 5 places situated within this boundary has been sold. So, my lord, my friend, my lord, we are resident in the border of the 2 districts, my lord. So, my lord, some of our residence is in the Borpeta district, some part of the residence in the Bongaigaon district, my lord. So, necessarily,
No, but where the Sutent falls?
my lord,
Where the,
Sweetland is in Bongaigaon, but boundary is of Borpeta district, my lord. The land is bounded by Borpeta district. My lord, north boundary of Borpeta district. So I may collect, my lord, some of my family may collect some records from Borpeta also, because my residential address is also in Borpeta district. My kindly have a look, my lord, to this address in this suit. They have mentioned my address is of Borpeta district. That's suitable. And they are saying that land is different district, and they are claiming.
to whom the shop belongs?
My lord,
Both shop,
my lord, my nephews, my lord. Land is owned by son and nephew, my lord. So, my lord, they are appropriate, my lord, representative of the dependent, my lord. The son and nephew can open, my lord, business, my lord, there. Kindly have a look at, my lord, my address, they shown in page 4 of the appeal. My address is of Borpeta district. Resident of village Langla, it's a bordering village of 2 districts, my lord. then Khudeja Khatun, district Borpata, village Langla, bordering district. So my lord.
No. The Suitland falls within Bongaigaon.
Yes, Bongaigaon district. Bongaigaon district boundary.
Bordering district is Borpeta.
Yes, my lord.
So something which falls in Bongaigaon district,
Yes, my lord.
whether the authorities in Borpeta district will issue
My lord,
trade license.
documents, only my lord, business, my lord. Trade license has been obtained from Borpeta district because their address is of Borpeta. So my lord, the boundary, my lord, is Borpeta district and the land is in the Bongaigaon district. That is correct, my lord. So if my address is of Borpeta district and you obtain trade license from Borpeta district and running business in the bordering of the district in Bongaigaon, now what is the, my lord, wrong, my lord? My friend is suppressing this fact. And my lord, kindly have a look at, my lord, my sale deed of 1994, dark number 370, quotidian number 196, and their sale deed also, my lord, annexed. We have annexed in the affidavit of opposition. Lordship may kindly have a look at page 103. They have purchased land only on 4/10/2023. The vernacular copy is at page 105. The translation copy, their date is wrongly mentioned. It is wrongly noted as 4/10/13, but it is 4/10/23. And their dark number of plot number, my lord, dark number 1190 and Mehdi Patta number 785, different. And boundary is also different. My boundary and boundary in my cell deed and their boundary in their cell deed is different. Tag number also different. Patta number also different. They have purchased land in the year 2023 and we have purchased land in 1994. How the cell deed of 2023 can supersede my cell deed in which was of 1994? Therefore, my plea is that their cell deed is a false. It's a false deed. And we have also submitted some complaint before the circle officer, and circle officer has, after verification, their mutation has been cancelled. They have no land. Kindly have a look at, my lord, the zone, the copy. I have annexed in my affidavit in opposition, annexer D.
Do you have this Karnataka High Court's judgment?
Yes, we have also relied on Karnataka High Court judgment. Yes, well. Fair enough. Hey, marking part to diya na. Marking part to. We have highlighted the relevant person. If my claim, my petition has substantiated the cause of action, recent cause of action, then injunction can be granted without counterclaim. But in the meantime, we have filed our counterclaim. That has been accepted also. Their mutation has been cancelled, my lord. And they have not made circle officer party. And they are claiming that we should make party my nephew and my son. Absolutely, my lord, a frivolous litigation. My lord, under para 3, the point has been quoted, my lord. Whether the defendant can move for an injunction.
When can defendant move an
My lord.
injunction
My
without
lord,
counterclaim?
under para 3. The question is this, whether the defendant can move for an injunction against the plaintiff without filing a counterclaim or issuing a writ in a cross action. In my opinion, he can in some cases, but not only in cases where the defendant's claim to relief arises out of the plaintiff's cause of action or is incidental to it. Barclays J also referred the decision of so-and-so. In my opinion, it must be relating to or arising out of relief sought in the action which is before the court, and that any other injunction cannot be properly granted in the action. My lord, here, my lord, we are of the cause of action, my lord, of their cause of action 2023. They have purchased land 2023, and now they are claiming that they are in possession. Absolutely false, and therefore the court has granted injunction, and they have not filed any injunction petition. If they are having any problem of injunction.
No, how your relief arise out of plaintiff's cause of action?
My lord, because they are, my lord, now they are trying to dispose us. We have
Why have you
apprehension.
not filed a counterclaim?
My lord, we have, in the meantime, we have filed.
No, but this, when this order was
For
passed,
immediate measure, we have filed the counterclaim, my lord, filed the injunction petition. My lord. Because we are apprehending to be evicted. Because their prayer is, in the suit, their prayer is that they wants to evict us. My lord.
okay,
They are
okay, help me
disposing.
to understand what this mean. He can in some cases, but only in cases where defendant's claims to relief arise out of plaintiff's cause of action or is incidental to it. What it means,
My lord,
according to you?
so far, my understanding is that they filed the title suit based on a sale deed of 2023, and their contention is to grab my land, my lord. So is it not a cause of action, my lord? They have challenged my sale deed. They have challenged my sale deed, my lord. Is it not a cause of action, my lord, to grant some protection, my lord, when we are apprehending with relevant documents? We have produced the sale deed, Jamabundi before the court, and the court has considered.
When have you filed the counterclaim?
My lord, my lord, we filed on 8/4/2025. My lord, this is our counterclaim, my lord.
At what stage suit is pending?
This suit is pending, well, because of this appeal and.
No, this
CRP.
appeal is only against miscase orders. It has not affected suit in any manner.
Trial court. So far instruction case is not proceeding, my lord. No evidence is taken, my lord.
Why?
My lord, after this proceeding, my lord, this appeal and
No,
CRP.
this appeal is not against the suit. This is
Trial
against,
court has not taken proceeding, my lord. Proceeding, my lord, the trial court. My lord, matter is not even to the stage of evidence. My lord, if evidence have been laid down, then matter would have been clear, my lord.
okay, what else is your submission?
Lordship, the e-courts.
No, let him complete.
My lord,
is shown as a written statement against the counterclaim, Your Lordship. It is next listed on 6/2/2026.
6/2/2026.
2026.
Or,
Written statements against counterclaim.
oh, yes, my lord. Then my counterclaim is now
It was recently
in
filed.
action, my lord. My lord, in the counterclaim, there is a prayer that their vendor has no right to sell any land because entire land has been purchased by us. So their sale deed is false, my lord. And therefore, the circle officer, after going through the records, my lord, their mutation has been cancelled. There was a mutation and has been cancelled. And they have filed this suit, while the suit on 9/11/23, and deletion of their names from Jamandi was 7/11/2023. My lord, they have not neither made party nor challenged this fact. And knowing fully well that their name is deleted, therefore this my cancel has been challenged, my lord, without challenging the deletion of their.
No,
name.
deletion, they have other forum.
It is challenged.
Against mutation, they need not to come to civil court. They have other forums.
My lord. But that is part of the facts. Therefore, at least the circle officer ought to have been made party in the case. They have not made party. This is a fact to be incorporated in this suit, my lord. But they have suppressed it. And they are knowing fully well that my boundary, my residence is of Bobata district. I am in the neighboring, resident of the neighboring part. Land admittedly in the Bongaigaon district, but neighboring land, border is Bobata district. So as per this, my lord, they are submitting in a wrongful manner, my lord. Not fair.
Anything else?
Since we have filed counterclaim has also been taken by into consideration by the court below. So, my lord, at this stage, my lord, at least, my lord, status quo as regard the suit property shall remain intact, my lord. There should not be any distance. If we are in possession, we should not be disturbed. That is my humble submission. They are claiming possession, absolutely false, based on no records, my lord. They have purchased, their sale deed is now meaningless. It appears to be false. How they can be in the possession, my lord? If they have not apprehended, non-filing any injunction along with their suit, that indicates that plea is not correct. They are not in possession. They are not apprehending anyway of being dispossessed, my lord.
Okay. Anything?
One small thing, the only fact that their address is of a different area of Barpeta district itself goes to show that the balance of convenience is in my favor, because I am a resident of the same village where the suit land is situated, 2 Katha 10 Lesa only, and I am in possession of the 2 Katha 10 Lesa only. They are the owner of a larger plot of land, whereas That portion is already in my possession.
Okay.
They are a resident of a separate district as submitted by.
In CRP, in FAO, heard Mr. B.J. Mukherjee, learned counsel for the appellant. Also heard Mr. S. This is item number? Item number 18. Mr. A.R. Sigdar, appearing for learned counsel, appearing for respondent number 1 and 2. This FAO under order 43 rule within bracket 1 within bracket R, small r, has been filed of the Code of Civil Procedure 1908, has been filed by the appellants impugning the order dated 29/6/2024 passed by the Court of London, Civil Judge Bongaigaon in Ms. J case number 27/2024 in connection with title suit number 149/2023, whereby the prayer for grant of temporary injunction in respect of Schedule B land by the respondent / defendants under Order 39 Rule 1 and 2 of the Code of Civil Procedure has been allowed. The facts relevant for consideration of the instant appeal, in brief, are that the present appellants as plaintiffs filed a suit before the Court of London, Civil Judge Bongaigaon, which was registered as title suit number 149/2023, praying for relief of declaration, and cancellation of, sale deeds, and for permanent injunction. In respect of which land?
Schedule A,
Schedule?
A land. And cancellation of sale deed in respect of Schedule B land.
Stop. It has been stated in the plaint by the present appellants, in their plaint by the present appellant, that the present appellant had purchased a plot of land measuring how much?
Measuring 2 kata 10 lesses.
2 kata 10 lechas from their vendor, namely Bilal Hussain. Stop. The said Bilal Hussain purchased the aforesaid land of 2 kata 10 lechas out of the total land measuring 2 bigha 2 katas 5 lechas from one Ataur Rahman in the year 1992. It is further stated in the plaint that the said Ataur Rahman, with his remaining three brothers again sold the entire plot of land of 2 bighas, 2 kathas, 5 lechas within bracket, including the plot of land which was sold previously by Ataur Rahman to the present appellants, comma, bracket close, in favor of the defendants. Stop. In the aforesaid, in their plaint, in the aforesaid suit, the plaintiffs have claimed for a decree of declaration to the effect that they are the owners and possessors of the plot of land measuring 2 kathas, 10 lechas, and more, which is more specifically described in Schedule B to the said plaint.
Schedule A.
2 kathas, 10 lechas,
Schedule A, Your
A. And B is,
the entire 2 bigha 2 katha 15.
which is more particularly described in Schedule A of the plaint. They have also prayed for cancellation of sale deed by which cancellation of subsequent sale deed by which the entire plot of land measuring 2 bighas, 2 kathas, 5 lechas were subsequently sold to the defendants. In the aforesaid title suit, the plaintiffs have, in the aforesaid title suit, the plaintiffs have also prayed for a relief of permanent injunction by restraining the defendants from disposing them from Schedule A plot of land measuring 2 kathas, 10 lechas. Stop. Next para. In the aforesaid suit, the present defendants had filed an application under Order 39, Rule 1 within brackets small a of the Code of Civil Procedure 1908, praying for grant of temporary injunction by restraining the present appellants / plaintiffs from dispossessing them from entire Schedule B land of 2 bighas, 2 kathas, 5 lechas, and by the impugn order dated 19/3/2024, the aforesaid temporary injunction was granted to the aforesaid impugn order dated 29/6/2024 instead of 19. 29/6/2024 granted the temporary injunction. Stop. Mr. B.J. Mukherjee, learned counsel for the appellant, has submitted that the impugn order of by which temporary injunction was granted against the present appellants, who were the plaintiffs in the aforesaid title suit, is bad in law. He submits that the defendants in whose favor the temporary injunction was granted by the trial court by the impugned order, had not filed any counterclaim when the said injunction was granted. He further submits that the defendants as petitioners in the aforesaid Ms. J case number 27/2024, in which the temporary injunction was granted, had failed to show the presence of essential ingredients like prima facie case, balance of convenience and irreparable loss in their favor. However, in spite of that, the trial court granted injunction to the respondent/defendants. He further submits that when the impugned order was passed, by that time, no prayer on behalf of defendants was there before the trial court praying for any mandatory injunction in the said case, which was obvious as no counterclaim was filed by that time. He submits that when there is no prayer for grant of permanent injunction by a party, no relief of temporary injunction can be. You mark out the paragraph number in Gadadhar. No relief of temporary injunction may be granted to said party. And in support of in support of continue, he submits that grant of temporary injunction in absence of a prayer for permanent injunction by the party to whom such a relief has been granted is bad in law. And in support of his submission, he has cited a ruling of this court in the case of Gadadhar Burman versus Rajendra Mohan Paul, reported in 1998 1 GLJ 2022. He further submits that the trial court, while considering the presence of prima facie case for grant of presence of essential ingredients for grant of temporary injunction, has also failed to take into consideration that the defendants in their application under Order 39 Rule 1 within bracket small a have only stated that the shops over the scheduled land is allegedly run by shops over the scheduled land is allegedly run by son and nephew of the petitioners in the name and style of Arzu Enterprise and Hassan Medical Stores. However, the son and nephew of the petitioners, of the defendants, were not made party in the suit. He submits that had there been any inconvenience or any cause of action for the grant of temporary injunction been there, it would have been at best in favor of the son and nephew of the defendants who are not made party to the case. He further submits that on the basis of mere pleading in the application under Order 39 Rule 1 and 2, without there being any documents on record or any other evidence to substantiate the claim of the defendants that the Schedule B property, that there are two shops over Schedule B property. The trial court granted the temporary injunction to the respondents, which according to learned counsel for the appellant was a wrong approach. He further submits that even the documents which are produced by the respondent in the instant appeal, that is the trade license in respect of the shops named Arzu Enterprise and Hassan Medical Store, shows that the said license were issued by 53 number Titapani Gaon Panchayat, Senimari of Borpeta district. In favor of one Rezaul Karim and the other trade license is issued by Rangapani Gaon Panchayat. No, this is in Bongaigaon.
This is
Second one is in Bongaigaon. In line to continue. He submits that when the suit property is situated in Bongaigaon district, production of trade license in respect of the shops from the authorities of Borpeta district does not have and is not sufficient to justify grant of temporary injunction to a defendant to the defendants who had not filed any counterclaim in the case. Yes,
Lordship, page 84 is from Bongaigaon and page
84 you are not objecting.
Lordship, 85, next page, Your Lordship. Hassan Medical Stores, Imanul Hassan. Even patta number is mentioned there, Your Lordship.
Learned As regards 85, what is your submission?
Lordship, it is stated here, Hassan Drug Distributor is hereby licensed to sell stock exhibit for sale so and so, situated at care of Jamaluddin, village Longla, near Longla High School, opposite PO Longla, PS Kolgatia, district Barpeta, Patta number 17, following categories of drugs. Is a drug license, Your Lordship, for Barpeta district.
He further submits that the trade license produced by the respondents in this appeal were not produced before the trial court at the time when the temporary injunction was granted. He also submits that even if the trade license are taken into consideration, same were issued in the name of persons who are not resident of Bongaigaon district, whereas the appellant is a resident of Bongaigaon district, and therefore balance of convenience ought to have been considered in favor of the present petitioner, present appellant in not granting the temporary injunction paid by the respondent. Stop. He also submits that the trial court also erred in granting temporary injunction in respect of entire B scheduled land, which includes the land covered by land under land described in A schedule of the plan, over which the appellant has his possession. Anything else? On the other hand, Mr. A.R. Sikdar has opposed the plea taken by the learned counsel for the appellant in his memo of appeal. He submits that though at the time when the impugn order was passed, no counterclaim was filed by the present respondents in the title suit number 149/2023, however, later on 8/4/2025, the defendants, within bracket present respondents, had filed counterclaim in the aforesaid suit seeking relief of a declaration of their right, title and interest over Schedule X land mentioned in the counterclaim. Another relief of declaration to the effect that the pro forma defendant namely Bilal Hussain, had no right to sell the land described in Schedule Y of the counterclaim by executing sale deed number 2134 dated 4/10/2023 in favor of the present appellants, and accordingly also prayed for cancellation of the sale deed. He submits that the present defendants in their counterclaim have also prayed for grant of permanent injunction against the plaintiffs from obstructing the defendants from running their shops. What is Schedule Y land? Is it Schedule B land?
My lord, we have, in the counterclaim, we have given our schedule, my lord, in our land, my lord.
It is a different
They-
land.
They have said B schedule land, here we said it is X schedule land. Then there, A schedule land, we have said as Y schedule land. I think that is the.
These are same
My
land.
lord, my lord.
Over, he लिख ले last line.
X schedule land, X schedule land.
Shops over Y schedule land, which correspond to Schedule A land of the plain. He further submits that as though at the time when the temporary injunction was granted, no counterclaim was filed by the present respondents in the aforesaid suit. However, there is no bar in law to grant temporary injunction to a defendant even when no counterclaim has been filed by him. In support of he submits that if the relief claimed by the defendants arise out of the plaintiff's cause of action or is incidental to it, then the temporary injunction may be granted to such a defendant, even in the absence of a counterclaim by such a defendant. In support of his submission, he has cited a ruling of the Karnataka High Court in the case of Sugandha Bai versus Sulu Bai and others, reported in AIR, 1975 AIR, within bracket Karnataka 137. What else was your submission?
My lord, we purchased in the year 1994
Okay.
and they have purchased in the year
He submits that
2020.
the land, the scheduled land over which the temporary injunction has been granted was purchased by the defendants in the year 1994 from
Bilal Hussain,
from
Siddiq Ali, Atar Rahman. At Lordship will find at page 72.
from
Our
Bilal Hussain, Siddiq Ali and Ataur Rahman by executing a registered deed of sale bearing number 2306 dated 8/9/94. He submits that the land over which the right title and interest is claimed by the present appellant is claimed to have been purchased by them in the year 2023, when their vendor did not have any such right to sell the said land. And therefore he submits that even prior to the filing of the title suit number 49/2023, the mutation of whose mutation was cancelled?
My lord, the appellant's.
The mutation
All the
in respect of the scheduled land of the appellants was cancelled by
Cancelled by the circle officer, my lord.
consent by the revenue authorities.
Yes,
And the appellants have not preferred any appeal against the said order. Neither they have mentioned that fact in their plaint. He therefore submits that the appeal filed by the present appellants under order 43 rule 1R is liable to be dismissed. I have considered the submission made by learned counsel for both sides and have gone through the materials available on record. Next paragraph, ... Diyo. I am reserving the judgment. The effective order heard both sides. Hearing concluded, judgment reserved. Aro hetu ready kori soft copy family matters আছে নাকি matrimonial matter আছে নাকি
My lord, in our counterclaim, para 4 and 5 is very relevant. If lordship gets time, my lord, 4 and 5 of the counterclaim. That was not because the full below at that time. You wanted to take me. We have given in a separate sheet, my lord. Counterclaim.
Okay, no, that is there. Mr. Sharma, the
Actually, your lordship, some negotiation is going on between the parties.
it is yes, Mr. Chaudhary. Will it be possible to complete?
Sorry to say, my lord, what happened, my lord? Last, my lord, Mr. P.K. Vasu's relative has expired, my lord. He
Who's?
got information.
Okay.
My lord, it's all right, you do that. Can it be day after tomorrow, my lord?
No, no, no. It may be in the,
Any date after 6th of February,
that may be exceeded. February, that a date.
Problem is, it will be 5th date,
After
my lord,
six.
they are taking, my lord.
after 6th.
There's a concurrent
10th.
finding in my favor. my
10th
lord.
February, 10th February, 10th. Heard, Mr. This is item number?
17th.
Heard, Mr. N. Hawk, learned counsel. Sorry, A.K. Azad, learned counsel for the appellant. Also heard Mr. A.U. Chaudhary, learned counsel for the respondents. It is submitted by learned counsel for the appellant that there is a bereavement in the family of engaged counsel for the appellant, and therefore he prays for an adjournment. Considering the submissions made by learned counsel for the appellant, Mr. A.U. Chaudhary, the learned counsel for respondent does not raise any objection.
That art matter,
Provide,
that does not raise objection. matter,
considering the submissions made by learned counsel for the appellant, the prayer is allowed. Let this matter be listed on 10th of February. It does not raise any objection, continue.
Public.